it's very difficult, the way they do it, to provide you with the whole question and our answer, and this isn't super clear on your attachment, but basically there was a question about the new pathway for international reciprocity. So basically they were asking if we were interested, and my comments basically are when the IAQB makes a decision and a recommendation for standardizing this, then we would certainly consider it. I do believe it's going to need a statute change, so that would be significant if we decide to move in that direction. So that was just the answers to that second part of the question, or the third question, I guess. The second question was, are we going to be considering uniform language to allow the use of management accounting designations? And at this point, this board was not interested in permitting those designations. So we can always revisit that, but that was how we felt the board was their stance at this point. On to the next item, TSCPA activities, just an overview of what I've done related to TSCPA. I attended their council meeting in November and updated the group on board activities. I attended the Upper Cumberland chapter meeting in November. They had a student day that day, so I shared more information on the new exam and that type of thing with the students at that meeting. Most of them were from Tennessee Tech. And on December 13th, I attended the Knoxville chapter meeting and gave a general update on board activities. Prometric secret shop, we touched on a little bit yesterday. I performed a secret shop at a Prometric testing facility as part of a process that NASBR reviews random number of facilities each year. So there's a set procedures I was supposed to do and a checklist of items to go in there and review their security features. So I did the closest testing facility was Huntsville, Alabama, so that's where I went, and they checked out fairly well. So I submitted my responses to NASBA. The annual review process, just to let you know, merit increases. They did approve increases for state employees effective January 1 of 17. All employees rated at valued or better received a 3% increase. Those that received a rating of advanced or outstanding received an additional bonus amount of 2% and 3% respectively. So I think that's pretty good compared to previous years of either no increases or modest. So staffing, we already addressed this earlier in our announcements with the addition of Leanne and Laura to the staff, and Ben is leaving, and when I wrote this report we did not have Liz on board yet, but we now have her here. And we talked about Don's position and our plan for replacing his position. Under renewals, we've done even-numbered licensees, and all firms renewed this past year. And you have some stats there as far as the number of renewals that have gone through and the number that have gone to expired grace, who have a little bit more time to comply with that renewal. At the end of January, each of those folks in expired grace will be assessed a $100 penalty for not renewing timely.
Cindy, that expired grace has now been shortened by actions we took to 6 months instead of a year.
Correct. That will be effective on January 26th, which is very soon. So we will attempt to communicate with these folks we are going to do, they will all receive an email on the rule changes specifically, and then we'll address it in our newsletter, which will go out before these people would fall in expired status. So. And we'll also ask the society to help spread the word on that. Let's see. And then the last part of this is simply some statistics. We have issued 697 licenses, individual licenses this year, and 68 firm permits. And then at the bottom of that last page is just our overall licensing population. So no particular items that I found alarming to note. Are there any questions outside of entertaining a motion on the January 8 or the May 18 date?
Hearing none, I would entertain a motion to add the May date in 2018 to our calendar of published dates for meetings.
So moved.
Second.
Second. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you, Wendy.
Thank you.
Next order of business is reinstatement request for Edwin Osborne, who I think is with us today. Eva, would you like to make that presentation, please?
Yes, Chairman. Members of the board, Edwin P. Osborne is here today seeking the reinstatement of his CPA license and CPA firm license. Edwin P. Osborne, well, let me give you a little roadmap of what I'll talk about, and obviously Mr. Osborne's here and can answer questions and speak with you as well. I'm going to walk through the disciplinary history of Mr. Osborne with this board. I'm going to share with you the facts section of the final order that resulted in the revocation of Mr. Osborne's CPA license and CPA firm permit. I'm going to talk about the compliance that was met by Mr. Osborne in an effort to seek reinstatement, and then I will share with you the section of the statute and rules that gives you the discretion and what the factors are to consider when looking for reinstatement. So in your materials, you should have, I believe on the iPad, a timeline of Mr. Osborne's licensing history with this board. The first complaint we received against Mr. Osborne was in 2002. This resulted from I believe, financial statement that was shared with us from the Motor Vehicle Commission at that time. In looking at that statement, it appeared that it was prepared while Mr. Osborne's license were both expired. As a result of that complaint, a formal hearing was held and a final order was issued in which the CPA license was to be renewed and the fees had to be back paid, I believe, on that one. So at that time, Mr. Osborne was, from following that, there ended up being a series of 3 more complaints that came in. The first was in 2007, which again has to relate with this time Mr. Osborne was licensed, but he did not submit for peer review, which would have been in violation of the 2004 final order. Additionally, a 2009 complaint was opened regarding a failure to file an audit on behalf of a client, which resulted in that client being penalized by the IRS. The potential penalty against that client was $5,260, but they were able to mitigate, and they abated that penalty to $500. And in 2011, on January 1st, 2011, Mr. Osborne's Kentucky CPA license was revoked, I believe as a result of a CPE missing. In April 2011, with this board, another complaint was opened regarding work that was done for a nonprofit organization after Mr. Osborne's, both of his licenses had expired again. In combination, all 3 of these complaints were put together into one formal hearing that was conducted in 2012 before this board. The disposition of the first hearing in that matter was a civil penalty of $4,000, revocation of both a CPA license and CPA firm permit. Following that hearing, Mr. Osborne appealed that decision to Chancery Court. When it was appealed to Chancery Court, it was discovered that the window of time previously thought that Mr. Osborne was unlicensed, basically, when his license expired, was actually shorter than originally believed due to an error. Originally, it was believed both permit and license were expired in 2006, but it turns out that his personal permit went to 2008 and the firm permit expired in 2007. Because of that discrepancy and because that length of time of that expired period was considered in the assessment of the penalty, the chancellor from the Chancery Court remanded the case back to this board to reconsider the penalty based on the new timeline of how long the licenses have been expired. After reconsideration, this board lowered the penalty to $3,000, continued the revocation of the permit and of for the firm and for the individual, as well as allowed an avenue for revocation, reinstatement after 2014, so long as back CPE was paid, was performed, as well as any fees that would have been not required. Mr. Osborne appealed that decision, but it was to the Court of Appeals, but that appeal was denied based on the timeliness of that petition. Looking at the final order, which really was the reason that this license was revoked and what ended up resulting in what was required for Mr. Osborne to be reinstated, I'd like to share with you the facts section so that you have an understanding of why the revocation occurred. Page 3 of the final order includes the amended findings of fact. This order is the second final order that was issued in that matter, so after the remand from the Chancery Court. It states, number 1, Respondent Edwin Osborne holds CPA license number 11166, which expired on December 31st, 2008. Respondent Edwin Osborne CPA holds a CPA firm permit number 3184, which expired on December 31st, 2007. Respondent Edwin P. Osborne CPA was required to provide proof to the Board of enrollment in an approved peer review program no later than October 30th, 2006. Respondent provided the Board with proof of enrollment in an approved peer review program on or about May 14th, 2007. In so doing, Respondent failed to provide the Board with proof of enrollment in an approved peer review in a timely manner. On or about August 1st, 2008, the Respondent performed an audit for the year 2007 for Stepping Out, Inc., a company located in Morristown, Tennessee. The Respondent did not possess a valid Tennessee CPA license and did not possess a valid Tennessee CPA firm permit at the time this audit was issued. On or about October 30th, 2010, Respondent issued an independent auditor's report to the Board of Directors of the Morristown Emergency and Rescue Squad, Incorporated, without a valid Tennessee CPA license or firm permit. To date, the Respondent has continued to practice accountancy in the state of Tennessee without a valid CPA license and without a valid Tennessee CPA permit. Mr. Osborne requested that this board reinstate his license this year, and in so doing would have to meet the requirements of that final order. The final order required that for reinstatement, Mr. Osborne had to submit his application and the $250 that's typically required. They additionally had to provide 260 hours of CPE, which is in lieu of the normal 80 hours we would normally require, in order to backfill the CPE that should have been done when he was conducting his practice without being licensed properly. Additionally, the costs of I believe the licensing fees also had to be paid. I totaled at $3,000, but could be offset through. I'm sorry, Wendy. How was that $3,000 offset? Do you recall?
Oh, I'm sorry.
That's all right. Ultimately had to pay $3,000. It's all been paid, and the CPE had to be done, 260 hours total. Through his application process for reinstatement, Mr. Osborne submitted certificates of completion for all CPE hours, as well as paid all back fees. And this has been looked at by our chief counsel as well to ensure compliance with the final order. And legal's final determination is that at this point, Mr. Osborne has complied fully with the final order and has provided all required reinstatement documentation. When considering reinstatements, this board is best directed through Rule 002001.10, subsection 4, or paragraph 4, rather. In considering an application, the board may consider all activities of the applicant since the revocation or suspension was imposed, the offense for which the applicant was disciplined, the applicant's activities during the time the license was in good standing, the applicant's rehabilitative efforts, the applicant's restitution to damaged parties in the matter for which discipline was imposed, and the applicant's general reputation for truth and professional probity. The board may also question the applicant, complainant, or individuals injured by the applicant. Members of the board, it is in your discretion today whether you reinstate this license, but as I stated, at this point, legal has no concerns over compliance with the final order. At any time you'd like to speak with Mr. Osborne or hear from him, he is available to you, and I believe there's also a written letter from him on your iPad.
Thank you. Mr. Osborne, would you at this point want to address the board?
First of all, I appreciate you.
Someone turn the mic on there, please. I don't believe it's. There you go. Thank you.
First of all, I appreciate you all giving me the opportunity to speak to you today. The issues, many of you may or may not have been a part of that whole proceeding. It's been a very difficult proceeding. The report you just heard said that I was not licensed and was issuing reports. The fact of the matter is that the court found that I was licensed and had met excuse me, all requirements for licensure, and the state was represented by the district attorney, who determined in their brief, even before it went to trial, that I had met all the requirements. I'd just like to put that in as an aside, and also make you aware of the fact that I have known Wendy and Brad, I guess 20 years. They know who I am. I have alleged all along that this was because of reporting to governors of Wendy's 3 predecessors, including one who was summarily fired by the governor, and 2 who were reprimanded because of misfeasance or malfeasance. But as you reconsider this, you should consider that I was licensed. The district attorney, I'm sorry, the Attorney General, I'm sorry, not district attorney, the Attorney General in their brief acknowledged that the staff had no reason whatsoever for the action they took prior to 2009, and that's why they remanded it back for reconsideration. Prior to that, my license was permanently revoked by this board, unanimous except for 1 abstention. I won't do anything editorial about that other than to state that as fact. You can go back and read the legal documents and confirm that for your own understanding. This process with this board has been very difficult. When I was licensed in Oklahoma with no problem, in Georgia with no problem, and in Kentucky with no problem, the normal time for getting a license reciprocated was about 90 to 120 days. For me, it was almost 3 years, although there were no issues. Back in 1990. In 2004, not only was I licensed, I submitted to this board. You notice the board in that 2004-2006 action didn't fine me a penny and took no disciplinary action. And that is because I had a fax in my possession issued by the office saying that my request for reciprocation when I'd come back from Florida had been approved. And yes, I did issue an audit report. And then I was later told that there was a clerical error and my name had not indeed been on the list that was approved by the board. That's why the board did not fine me in 2006. They took no action other than to order immediate reinstatement about my license, which the staff did not do. So that's been a history. I would say that it's not a matter of a legal record, but I would say that it does have something to do with Wendy's predecessor, Darrell Tungate, being fired on my when I provided evidence to Governor Bredesen of things he was doing. The others, I don't go off half-cocked, but that has everything to do with not the fact that I was not licensed, but a conscious choice by the staff to delay or not license me and represent that I was licensed. That's my summary comment. Thank you.
Mr. Chairman, I'd like to go on record as saying I'm going to recuse myself from this matter fully. Mr. Osborne, and I appreciate you coming today, sir, is in his letter stated that one of his reasons that he believes he has been mistreated, I guess, by this board is because of some whistleblowing activities regarding irregularities in the state's Medicaid program. And even though I have no knowledge of that, given my current position in the state's Medicaid program, I'm going to back out of all this to make sure that, out of an abundance of caution, that the board's actions aren't tainted by my involvement.
So, Mr. Gabe Roberts is recusing himself from any discussions on this matter. Have questions from the board of Mr. Osborne? Would you outline for me how you got your CPE? We've got certificates on it. Just walk me through the process on how you obtained your CPE.
I went to an approved carrier, NASBE carrier, and downloaded and completed those courses. A variety of tax, auditing, accounting, consulting, the whole ball of wax. I actually completed more than 260 that was required by this board just to make sure that if for any reason the board saw fit not to accept one or there was some technicality, just to be covered.
Out of curiosity, I mean, and what raised the question is that on your report, you had the 200 and however many hours it was in excess, granted, all showed up over a 2 or 3 day period. Did you just accumulate those tests and send them in, or how did?
Well, I had been, since the order came out, some of the courses changed, but I actually did the final exams in more bulk, but I did the actual coursework over a period of about a year.
You actually were doing that over a period. It just looked to have them all done in the last day or two obviously raised questions.
Well, I didn't want the board to disqualify me because they were old. I have had a long history of everything I've been done disqualified by this board illegally.
We're here today to look at if you've met the requirements for reinstatement, and the history's been presented to us. Yes. If we can leave that behind, this is the board that's...
I'm happy to do that, yes,
well,
believe me.
We also would like to just leave that on the table and address today on its merits.
Okay.
Do we have any further questions?
For the record, does anyone in legal understand the discrepancy between the record saying that that Mr. Osborne was unlicensed and he's saying he was licensed? Is there some explanation for the discrepancy there?
Yes, I think there's sorry, apologies. I think there's a misunderstanding on what the remand is of where that comes to be. Mr. Osborne was licensed up until 2008 personally, and is 2007 on his CPA firm permit. There was Mr. Osborne's name didn't make it into a reapproval list, or was there an administrative error? There isn't facts really in the record of what exactly it was. I know that the state on remand admitted quickly that there was this discrepancy of time, and they'd like it considered by the chancellor. So Mr. Osborne's license did expire. The only debate was when it expired, and I think debate is actually not really the right word, because after it was discovered that there was probably more time that the license was still at least in a grace period, that was addressed, and that was the reason for the remand.
Even with the difference in date, there was a period there that legal is
yes.
of the opinion that he was unlicensed and was practicing as if he was.
That's right. During that time period is when all the time that fell after the expiration of those licenses is when we received proof of different audit work being conducted.
May I speak to that, please?
Yes, sir.
In 2008, I put in writing a request for a hearing because what I had been told was that my license had been suspended. In testimony showed before the state board there was no category. Now, the board has since changed that, but there was no provision for suspending a license. It's either active or it's not. And Wendy's predecessor explained was that they were conducting an investigation. That investigation took 4.5 years between the time that I filed a request for a hearing before this board and the time that the hearing was actually granted in 2012. So it's nebulous because the previous executive director coined a phrase that is not anywhere in the literature called suspended in order to keep me at bay while they investigated for 4.5 years. So that's why there was a question about, exactly when things expired.
So it would be your opinion that you were never practicing without a license, there was just a misunderstanding? Is that what you're saying?
Well, what I demonstrated in Chancery Court on 2 different occasions that I appealed actions of this board was that I was able to demonstrate that I had met all the requirements, and the Chancellor agreed, and that's why it was remanded back.
Members of the board,
Thank you.
you have copies of that final order, and you also have the Chancellor's order. And so at this point, I would just emphasize to this board that those issues have been resolved in every court that we have access to. And so just to emphasize that it may not be in this board's best interest to rehash some of those facts, but rather to just review the actual finalized orders.
What's the status of your Kentucky license?
My Kentucky license was made inactive as a result, the direct result of the action of this board, as was my securities license. I have 3 federal securities licenses, as was my right to practice before the IRS through the Office of Professional Responsibility. And anymore, there is a uniform reporting. If one state board nullifies your license, then it's that way across the board. I am very eager to get all those licenses back, but this was a downstream, that was one of several downstream actions affecting me based on the action of this board, actions plural of this board over a 10-year period.
Legal, would you address that?
We've tried to reach out to Kentucky to figure out the precise reason for the revocation of the license. We don't have evidence one way or the other if that was based on reciprocity. At one point, I believe Wendy saw something that indicated it was CPE related, but I would not stand on that today as a fact because we have not been able to confirm that with Kentucky at this point.
They list his license as revoked, not inactive. So, just for clarification.
Your original certificate was a Tennessee certificate.
It was not. It was Georgia. At the time, I worked for Deloitte Haskins and Sells in their Atlanta office.
You still have a Georgia license?
I do not.
Members of the board, I would not be able to opine whether the license actions in other states were, as we know with other cases, it is a possibility that the revocation action here resulted in reciprocal discipline in these other jurisdictions, but at this time we don't have access to exactly why those licenses were revoked.
Mr. Chairman, based on legal counsel's representation that Mr. Osborne has complied with the final order in all respects, and this has been a long, drawn-out process for Mr. Osborne and for this board. And, if he's done everything that was included in that final order and legal counsel is satisfied with that, I'd like to make a motion that we approve his application for reinstatement. And hopefully somebody will second that, and if there's more discussion, we can have it at that time.
Have a motion on the floor. Do I
I'll
have a
second it.
We have a second. Is there any further discussion?
I have one technical question. Just looking at the CPE records, and it may be okay, but there's 2 courses here, 1050 and 1055, that say he took version A and version B. Is version A and B, is that just an update of the same course? Can you get credit for the same course twice if there's a different version out?
That is a consequence of starting a course, and then they either changed or in some way rescinded the course or updated it, and I did the work on both courses, and so they offered the CPE for the old and the new.
Yeah, I just wasn't familiar with whether you can get credit for both.
It's not identical, no.
Yeah, okay.
Any further discussion?
Chairman, one question, if I may, directed to Mr. Osborne. As we've looked through the record and what legal is described and the background information and the reinstatement application that you have provided, going forward, setting aside the past, but going forward, if the license is reinstated by this board, the issues that have been, I guess, the heart of the past activity have been related to CPE and peer review. and licensure, issuing with or without, an appropriate licensure. Would it be your commitment going forward, if the license is reinstated, that you would expect to maintain compliance with the board's regulations with respect to CPE and peer review to the extent that it's applicable to you in your practice?
Absolutely.
Legal, I have one quick question.
Yes, Chairman.
Can we, and I have no problem, just to preface this, I'm just asking for technical, because I don't want him to have to come back again. Is there any problem with us granting him a license, renewing his license, when he does not have the valid original license? It's my understanding from memory, and this is why I'm asking for guidance, that you have to maintain your original license that you passed under permanently.
I'm not aware, because the license was never, it was set in revoked status, so even though in practice that means the license doesn't exist, it doesn't not exist. It's just set in revoked status. So the license hasn't been dissolved, or he hasn't had to retest for that license.
I'm referring to the Georgia license,
I
his
apologize.
original license. I'm sorry for not being clear.
Oh, I am not sure of that being a requirement. I'm happy to take a minute and look at that and check with that, but I've not heard of, I'm not aware of that requirement.
By a matter of practice, we have not, if somebody reciprocates to the state and got their license in Texas 20 years ago, we have not required them to maintain that license.
Okay, that's fine then. That's clarification I was looking for. I just didn't want anything to derail what we're trying to do today. So, legal's huddling.
I had to confer with your expert counsel. Upon legal conference, the license existing in Georgia, even though that is the original license, and this license was granted on reciprocity, the status of that license under our laws is not tied to the license that you have.
Thank
so
you.
can, if any discipline happened, you can take discipline.
Any further questions? I'd like to have a roll call vote, please.
Pamela Church.
Aye.
Gabe Roberts.
Abstain.
I'm sorry. Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Mr. Osborne, this board believes in what you've done, that you've done what you needed to do to get your license back, and hope that whatever was before us is behind us now. So,
I do have a couple of questions in terms of the length of the renewal period and how quickly can I get this done. The Office of Professional Responsibility of the IRS is waiting for the actions of this board, and I need to get that to them yesterday if I could.
Mr. Osborne, we should be able to process this on Monday,
Thank you.
and the license, you must have it will expire in 2018. You have an even license number. So December 31st of 2018, so you're basically at the beginning of a 2-year period.
Very good. Thank you.
And so we'll be in contact on Monday.
Okay.
thank you for coming today, sir. Moving on to the next agenda item. Request for reinstatement for Teresa Holder Burt. Leila, would you make your presentation, please?
Yes, Chairman. Teresa Holder Burt is seeking the reinstatement of her license. Teresa Burt's license was revoked as a result of an order from this board, or as a consent order. The board authorized settlement via consent order for a complaint in 2013 related to a failure to respond to a CPE audit. The settlement required the respondent to pay a $500 civil penalty, and for them respondent to provide proof of 104 hours of CPE to the board within 180 days of execution of that agreed order, or consent order rather. one of the terms in that order was that if the order wasn't complied to in the timeline set out, that the license would be automatically revoked. In 2014, the consent order was fully executed on April 22nd, which included those terms I just described. The civil penalty was paid the next day, but the CPE was not submitted. The license was revoked on October 23rd, 2014, as a result of not complying with the 180 days to get that CPE finished. In June 1st, 2016 is when we received the reinstatement application, as well as the submission of 85 hours of CPE from the respondent. At the board meeting in July, the board determined that the application was incomplete because there was 24 outstanding CPE credits. The board voted unanimously to review the application and CPE at the October meeting. Staff contacted Ms. Burt and let her know that she had this deficiency, and Ms. Burt said she would complete those CPE credits. At the October meeting, the board met to discuss it. However, the CPE hadn't been submitted. But what ended up happening is while we were all down here in the board meeting, the CPE was submitted. So while the board meeting was being conducted. When Ms. Burt was informed of this, she explained she didn't understand the timing and didn't realize that it needed to be in before the start of the meeting and wasn't aware of the time limitations of that. Because of that, she did submit the rest of the CPE required to her, and she says that she was confused in the process, and she was informed that we would bring this to this meeting and allow you to reconsider her application. At this time, Ms. Burt, according to legal, has fulfilled all of the requirements of the consent order. Obviously, it went overdue, but she has met those terms, and she's filed her reapplication process and paid the fee that is required with that. She submitted a letter, which I believe you have on your iPad, explaining the history of why she didn't seek reinstatement earlier, and cites a number of personal reasons on why that wasn't able to be completed. And it is, as just as before, this is in your discretion on whether you grant this license or not.
Thank you. Question, Wendy, when this came in, she's an even number. If we reinstate, her CPE is up to date, is that correct? Through
Correct.
the end of 16?
Correct.
Thank you. So she would, like Mr. Osborne, in the 2018 renewal
Correct.
window. Thank you. We have any further questions or discussion on this? I'd entertain a motion for action.
I would make a motion that we approve reinstatement of her license. And again, she has complied with all the requirements of the consent order, and I read her letter regarding her personal circumstances and could understand how she failed to meet some of those deadline dates. So I move that we approve the reinstatement application.
Have a motion on the floor. Do I have a second?
I'll second that motion.
Have a second. All in favor of the motion signify by saying aye.
Aye.
Any opposed, like sign. Hearing none, the motion passes. We'll go to board committee reports. Mr. Elmore, licensing committee, sir.
Licensing committee has three issues, I guess. First two, or the first one was related to the new process of the CPA exam, which will be causing issues with candidates who have carryover credits, and those taking the exam in the second quarter of 2017 will potentially have an issue with an expiring credit in the third quarter, and the committee feels like we should the committee would like to make a motion to the board that these candidates who take the exam in the second quarter who have credits expiring in the third quarter, that we would allow them time to carry those credits over to 12/31/17 to allow them to, because of the fact that they're not going to have opportunity to find out their grade on the second quarter exam before they expire.
As a matter of record, this is because of the exam changes, the format, and they're taking extra time to prove the validity of the exam before they issue the grades, and we do not want to, as a board,
Penalize those.
to penalize those.
Suppose there's going to be a one-time thing in this second quarter of 17. It's going to take longer to grade and get the results out. So we would like to make a motion to allow extra time.
Do I have a second?
Second. Oh, sorry. You go ahead.
Second.
Second by Ms. Church, in honor of all of her students. She actually made, for the record, she made the motion yesterday in committee. Any discussion on the motion?
Matter of discussion, I think we talked further about how we would inform those candidates about the process, and that Wendy would do some communication with those candidates to give them comfort before they take the exam that this is going to be a carryover period.
ASBA is to provide that list to you. Is that correct?
Yes, I'm not sure we can do it before they sit in the second quarter because we won't know for sure. So they'll be able to identify those folks after they sit.
Thank you. Any further discussion? We have a motion and a second. All in favor signify by saying aye.
Aye.
Opposed, like sign. The motion carries.
Second item of discussion it would be we had an application for a firm name for NGP Capital. The committee met and discussed at some length about whether that was a fictitious name, falling under the rules of 0020-03.15, and determined that it was somewhat of a fictitious name, but that we didn't think it was misleading enough to not approve the name. So the committee would like to recommend that the firm name of NGP Capital be approved under a section in that same section that says that even if it is fictitious, it can be approved by the board.
That's made in the form of a motion.
Second.
And we have a second. Any discussion on the name?
I'm just going on the record and say again that I think that we should hold off on approving these until we get some clear standards about what we agree as a board is acceptable. I think there's a gap in the rule right now, and I think it's entirely appropriate, since it's our discretion to approve fictitious names, to do that. I know we've had this robust discussion before, but just going to put it out there again.
I would have to agree with you.
I would also say that I agree with that, too, so.
Any further discussion? I'd like to have a roll call vote on this one, please.
Pamela Church.
Aye.
Gabe Roberts.
Nay.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Nay.
Don Royston.
Aye.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Motion passes. Next name, sir.
Wendy, can you refresh my memory on the third item? I didn't write it down, but you had passed out something yesterday.
And I don't have it in front of me, but it was Avant-Garde Accounting Services. Is that-
LLC.
do you have it?
Avant-Garde LLC Services, Avant-Garde Accounting Services
It's
LLC.
Yeah. It was approved, you recommended approval yesterday.
But I just don't remember what we recommended. Was it a firm? It was a firm name.
Yeah.
Yes.
Yes.
I recommend approval of the firm name titled Avant-Garde Accounting Services LLC.
I'd like to make the motion that we approve that name for a firm name to the board.
Second.
We have a motion. Do we have a second?
Second.
Okay. Discussion on it?
I think we should wait and not approve these names until we have more consistency and guidelines of what we think is acceptable.
I agree with that.
I also agree with that. Can someone tell me what avant-garde means?
I'm looking it up right now.
I haven't.
Avant
That's his nickname.
His alias nickname.
That's an alias nickname, but he's put the whole word in there.
Guard means he guards his clients from bad.
That's
Avant-garde, the French word, I guess, per the Google machine, says that it is the avant-garde from French advance guard or vanguard, literally foreguard, are people or works that are experimental, radical, or unorthodox with respect to art, culture, and society. Not something that I think is appropriate as in a CPA firm name, personally.
I would have to agree with that. That's why I looked the word up. I wasn't sure what it meant, and you're dealing with taxes in this particular case, but what happens when he goes into, if they decide to go into test services?
He does do a test and is enrolled in peer review.
It's used informally to be modern or cutting edge, which I think is appropriate.
I believe he described Avant as a nickname of his over a long period of time.
I think this is a clear-cut case of misleading, right? I mean, this is something that even if it's spelled differently, if you hear avant-garde, especially for folks, I guess, who are Francophiles, they're going to identify what that means. And I guess the question would be, are we okay with somebody practicing in this profession with a name, even if spelled differently, that means that? That seems to me clearly misleading. Are we experimental, or radical regarding a test services? Is that what we're doing? Maybe it is, but that just seems, this doesn't even seem like a gray area to me.
This definition says unconventional or forward-looking. Another one says ahead in position, time, or manner.
Again, do we want to have somebody that's unconventional with regard to a test services? Is that what we want to do? Maybe it is, but it's a question I think that's fair that we should discuss before we approve it.
Would we approve Tennessee's best accounting and tax service?
Best implies a different judgment.
Further discussion?
I took some comfort yesterday that this one at least had accounting services, or accounting as part of the name, so there's less ambiguity as to what they are about. I also, to me, it's relevant that they are enrolled in peer review, and I would, in this particular case, I would prefer to have the entity subject to firm registration and oversight on the part of the board than not.
I agree with that. I just want to make sure we understand the only issue before us is whether we approve this firm to operate under this name. That's the only issue. I mean,
I would point out that if they are doing a test work, they have to be licensed by this board. So this is not like the other one where they were only providing tax services, I believe.
this is merely, they're requesting the privilege to provide the services that they have to be licensed to provide under a name. That's the only issue.
Approve this firm name, what happens?
They'll have to choose a different name.
They can still operate, but they'd have to choose a different name.
Is that correct, Wendy? Or legal?
What happens in the time period when they're trying to get the second name approved?
I believe
Wendy could approve a name if she felt it met the rules.
I believe the rules state they have 30 days to come into compliance or something of that nature.
If they came back and chose his real name, I mean, she could
Yeah,
approve
then
that.
we would approve, we would go ahead and approve
It
it.
would not come through this board again.
Yeah, I would like to say I believe there's actually two fictitious names in this, Avant being a nickname that he has used for a long period of time, and Guard is, whatever it means, is totally, in his own email explanation, is separate and apart from that. So I believe there are two fictitious names in here, which is I think a clear violation of that particular rule. So that's my interpretation.
This may be unprecedented or unconventional, but what happens if I withdraw my motion? As chairman of that committee, if I withdraw my motion, does it revert back to the committee without?
The motion's already on the floor, and we're discussing and voting on it,
Okay.
I mean, now.
But
So
if
we
I
can,
change my mind on the motion, how do I do
you can
that?
vote your heart.
Vote no.
So the
after the
motion's out,
discussion.
second's there, so I can still vote in opposition to the same motion that I made?
That's correct. Is that not?
That
That's
is correct.
Okay.
Someone could also motion to amend the motion.
I wasn't aware, or I didn't remember yesterday in the discussion at the committee, that this firm was involved in test services. I didn't.
Likewise did not.
That changes my opinion of the name.
The other thing to remember is that subsection 2 states that they're supposed to have a name in them. Now we have, and there's back to what Gabe has said before, is that we, with the new generations, we really need to bring before this board a look at the names that we're going to approve, or we're going to open the door we can't close.
Doesn't have to have a name in it, it just means it comes before the board if it doesn't. I think a valid question is avant-garde as used together as that one term or two, because there is a separate rule that says two fictitious names automatically disqualified. So I think that's a valid question.
Vote on the motion.
Any further discussion? Let's have a roll call vote on this one, please.
Pamela Church.
Nay.
Gabe Roberts.
Nay.
Trey Watkins.
Nay.
Stephen Eldridge.
Nay.
Casey Stewart.
Nay.
Don Royston.
Nay.
Janet Booker Davis.
Nay.
Judy Weatherby.
Aye.
Gay Moon.
Nay.
Larry Elmore.
No.
Kevin Monroe.
Aye.
Motion is denied. Did you have that complete your report?
Yes.
We actually need a motion. All you've done is said that you're not going to approve it. You need a separate motion to deny it, I believe. The first motion was a motion to approve it, and that failed, or that vote failed, right? So you haven't actually denied the name, you just haven't approved it at this point. If that makes sense.
Mr. Chairman, I make a motion that we actually affirmatively deny the name Avant-Garde in this case.
Thank you for the motion. Do we have a second?
Second.
Have a second. All in favor signify by saying aye.
Aye.
All opposed, like sign. We have an opposed to the...
And Judy, correct? Judy was opposed and Kevin was opposed.
Thank you, legal, for catching that. Law and rules, Trey Watkins, please.
Yes, yesterday we reviewed the draft peer review rule for submission of peer review results starting in, 2018. I would ask that this board approve those draft rules, the draft rule.
Second that if it's a motion.
It is a motion.
We have a motion and a second. Legal, would you like to, we need to read this into the record?
Yes, that would be, if you don't mind.
I
do
would
that.
love for you to read it into the record.
This rule would add a new section to the current existing chapter 002006. This new rule will be titled Peer Review Submissions and will be 00206.07. Paragraph 1. Within 30 days after the acceptance of a peer review, firms shall submit a copy of the results of its most recently accepted peer review to the board. The required documents include A. Peer review report, B. Firm's letter of response if applicable, C. Acceptance letter, D. Letters accepting the documents signed by the firm with the understanding that the firm agrees to take additional action if applicable, and E. Completion letter if applicable. Paragraph 2. Notwithstanding any provision of this rule to the contrary, for peer review commencing on or after January 1st, 2018, all peer review documents referenced in paragraph 1 shall be made available to the board by the approved peer review program's administering entity through a secured website process within 30 days after the acceptance. Paragraph 3, firms shall satisfy the submission requirement in paragraph 1 by authorizing the sponsoring organization to provide the board access to the documents via a secure website process. The authority for this section is TCA sections 62.1.105 and 62.1.201. And at this time, I would request a roll call vote.
Before we do that, can I just put one thing on the record to develop it, just in case this ever comes up and we're all long gone? Once again, C&I Legal has provided incredible advice to the board. And yesterday, Mr. Glendorf went through we had an issue about whether or not this would inadvertently circumvent the confidentiality protection on peer review records in the statute. And Mr. Glendorf made a comment that was, I thought, really good. And he basically said that, if for whatever reason we come under attack and somebody challenges the confidentiality of the records that a firm submitted to the board because it wasn't the actual peer review committee itself, The definition in TCA 62-1-201, Section A, includes as the definition of review committee, it says it means any person or persons carrying out, administering, or overseeing the peer review. And we obviously, as the board, are overseeing the peer review and are charged by statute of doing that. So I think that's a really good point that we need to make sure we preserve for the record in case this issue comes up, for the protection of whoever it may be who's the subject to a peer review that may come before us.
Good point, sir. Thank you. Any further discussion?
I would recommend allowing for public comment if there is any here today. I don't believe there is, but I think this is good practice to ask.
Anyone from the public sector that would like to make comments to this? None. We'll call for a roll call vote then.
Pamela Church.
I believe we need a motion to adopt the rule.
It's already
Is there
on
a
the
motion
floor.
to adopt? Okay.
Gabe Roberts.
Aye.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
John Royston.
Aye.
Janet Booker Davis. Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Motion passes unanimously.
As a part of passing a rule, members of the board, additionally, I will need this board to approve the attached regulatory flexibility addendum, as well as the impact on local government statement and additional information for the Joint Government Ops Committee. So I believe the best way to, you don't have to roll call vote. What I'll do is read each question into the record, and if there's any discussion or edits that you would like, feel free to let me know. We can make those edits despite the fact that the rule's been passed, since this will go to outside agencies for their approval. So I believe that's also included with your rules, so you can follow along.
They don't have to roll call vote on those 7 questions that are separate. They need to roll call on the 6 included in the back.
This one?
Or maybe the ones in the packet, they don't need a roll call, the others that aren't included.
These ones needed?
No. They see roll call to about this and that.
Okay, I apologize. What I'll do to expedite the process is I'll read the entirety of the addendum and the impact statement. Those will require a roll call vote, and then the last one does not. And I will make sure to stop and say this will be a roll call vote so that we can follow along. So I will have to read it. I know it's a little long, but I'll do my best to get through it for you. This is the regulatory flexibility addendum. Pursuant to TCA 45401 through 45404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. We have done this through the form of 6 questions, and these analyze the impact on small businesses from the perspective of what this rule does. Number 1, the types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. As of January 2017, the Tennessee State Board of Accountancy has 1,760 actively licensed CPA firms that will be substantially impacted by the rule. Under the newly passed peer review laws contained in TCA Section 62-1201 at SEC, these firms may be subject to disclosing peer review documents to the Tennessee State Board of Accountancy. Therefore, the majority of small business CPAs will, through this new rule, avoid the expense of producing paper documentation at the request of the Tennessee State Board of Accountancy, and rather will be able to utilize online portals for instant electronic submission of documents. Number 2, the projected reporting, record-keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. The new rule mandates the use of electronic portals and disclosing peer review documents. Currently, the peer review provider utilized by the vast majority, if not all, firms in Tennessee already have such a portal. This rule will require Tennessee firms to allow the provider to make available documents to the board through the portal. Other than ensuring the firm has not opted out of the online service, no other costs outside of what is already in place will be required of small businesses. No professional skill will be necessary to implement this rule. 3, a statement of the probable effect on impacted small businesses and consumers. Small businesses will need to be ensured their peer review program is making documents available on the peer review program's online portal. This impact is less burdensome than the alternative of requiring the licensee to produce paper versions of the documentation. Outside of initial authorization, the peer review program will make the documentation requested in the rule available with no need for the licensee or small business to do any extra steps. Consumers will be positively impacted because this rule will increase the board's ability to oversee peer review results in an effort to ensure peer reviews are conducted properly and to monitor licensees for potential violations. Consumers will benefit from the added accountability and oversight from this board. 4, a description of any less burdensome, less intrusive, or less costly alternative methods for achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small businesses. The board believes that the rule is not burdensome, intrusive, or costly. Therefore, no alternatives are reasonably expected to be less burdensome. 5, a comparison of the proposed rule with any federal or state counterparts. There are no known federal or state counterparts to this rule. 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Exemption from the rule would not be expected to be beneficial for small businesses because their rules. Their rules. Oops, I got to fix that. These rules simplify the peer review disclosure process by allowing the already existing peer review programs to ensure compliance through the already operational online portal. Ultimately, this process will have a net positive gain, considering the alternative would be to require small businesses to produce physical copies of what can be voluminous documentation related to the peer review process. Additionally, the peer review process and documentation is already being produced. This rule solely allows these documents to be shared with the board as allowed in TCA 62-1201 et sec. Also included in this vote will be our impact on local government pursuant to TCA 45220 and 45228. Any rule proposed to be promulgated shall state in a simple declarative sentence without additional comment on the merits of the policy of the rules or regulations, whether the rule or regulation may have a projected impact on local governments. We have written this proposed rule will not impact local governments. At this time, we would request a roll call vote to adopt these considerations of the rule and also entertain any discussion if you'd like legal to modify any of these answers.
We have a motion to approve as presented to us.
So moved.
Do we have a second?
Second.
Any discussion on the motion? And that has only the one correction in it, changing the word to these from there in what was presented to you and typed. Roll call vote, please.
Pamela Church.
Aye.
Gabe Roberts.
Aye.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Motion carries unanimously.
Thank you, members of the board. The next step to ensuring we have this rule passed properly, it's not written in your documentation, but it is the adoption of 6 questions that have been mandated through the Regulatory Flexible Act of 2007, Section 45402. These questions are going to how it would impact local government. And as you saw in that impact government statement, at this point, legal doesn't anticipate any impact, but there are 6 questions that I need to state on the record and that we don't believe there will be an impact. The first question from subsection 1 of that statute is the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local government rules. It is legal's perspective and opinion that at this time there will be no overlap or interference with any state, local, or federal rules due to this being a unique system. Question 2 is the clarity, conciseness, and lack of ambiguity in the rule. Legal states that this board believes the rule to be clear, concise, and lack ambiguity. The third is the establishment of flexible compliance and reporting requirements for small business. This board believes that this rule allows flexible compliance by initiating an online application process, utilizing a system that is already in place for these licensees. Question 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. This board believes this rule allows a friendly schedule or deadline, considering it utilizes an already implemented system, and the deadline of January 1st, 2018 allows peer review programs time to implement this rule internally. The fifth question, the consolidation or simplification of compliance or reporting requirements for small businesses. This board believes this rule will consolidate and simplify the process required by its new statutes, allowing this board access to peer review process by implementing an online system of access to these documentation. And sorry about that. 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. This rule doesn't establish any performance standards for small businesses other than ongoing compliance with disclosure rules. Number 7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. This rule was crafted with the idea that this is an innovative system utilizing electronic means available to licensees in peer review programs currently, and therefore it does not increase costs and allows for adaptation and allows innovation. If this board approves of these answers to these questions based on its impact on local government, I would request a vote. I do not believe it needs to be a roll call vote. Oh, it does. It does need to be a roll call vote. I apologize.
Okay, would someone like to entertain a motion to approve those questions just read to us and their answers?
So moved.
We have a motion on the floor. Do I have a second?
Second.
Have a second. We do need a roll call vote.
Pamela Church.
Aye.
Gabe Roberts.
Aye.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Members of the board, that completes the adoption of this proposed rule, and from this point, it will be routed through chief counsel, deputy counsels, all the way up to the commissioner, and at that point, it will be sent to the attorney general's office as well as to the secretary of state for review, and we'll make sure to keep you updated of that process. And additionally, we'll also make sure to keep you updated on the with Liz's work with Wendy on getting the rest of those rules renewed for you so that you'll have, by the next meeting, a comprehensive peer review package to look at. Thank you so much for your cooperation on this.
I think it's my cell phone next to a mic. Mr. Royston.
Our chairman.
Yes.
In addition to our committee meeting yesterday, we also discussed the status of the pending rules, which are imminent, it sounds like. You want to update the three rules? What did we?
Yeah, 2 sets that included those items I mentioned yesterday. Yes. And those will be effective on January 26th. And all licensees will receive a notify if we have an email address on file with details and links to the actual filing.
And we also asked staff to pursue some information regarding the fictitious names. So hopefully we'll have some information to look at the next meeting. But with that, we conclude the Law and Rules Committee.
Thank you, sir. Good report. Okay, Executive Committee report. Wendy, you want to follow the same agenda we did yesterday on financials, et cetera?
Sure.
Each one of these will be found on your iPads with any updated changes that we would have made yesterday.
All right, so first on the committee's agenda was the update on the FY17 year-to-date financial results. I'll just give a brief overview that this is as of, so the fiscal year begins July 1st of 16. This represents 5 months in for the period ending November 37 or 16. As to date, we have revenues of $346,930, less the anticipated state regulatory fee to date of $31,000. That brings our net revenues to $315,000 to date. I went through, I believe, each line item yesterday, clarifying kind of where we stood, whether we were favorable to budget, and if there were any concerns, which I don't believe there were any yesterday. Our expenses to date are at $237,632. In addition to a projected cost backs from the Division of Regulatory Boards of $96,000 for a total of $333,763. So we are in the red by $18,000 and change. We expect that revenue from renewals through December 31st will show us with excess revenue beginning next month. So I believe we are in a good position. Were there anything I missed?
Can I ask a question? I didn't ask yesterday. I'm sorry.
Sure.
Are we in a position to consider doing another fee reduction for licensees or renewals? I don't know if that's something we've thought about. I know we did it a couple years ago, but is that something that's on the board or the table, I guess?
We can certainly maybe put together a study. I'd like to see how we end this fiscal year, because we were in the red last fiscal year. So I would contend it's a little early. I'd like to see how we end this particular fiscal year.
Discussion on that? Good question, though, Gabe.
Okay. Ready for the next one? Okay. Next item on the agenda was the travel information, which I just shared travel information for myself and Dawn for since the last meeting in October. I believe there were some items noted about how much travel that Dawn had done over the time period, and that is basically attributed to state-specific ethics presentations. He did numerous presentations over that time period, and that's typical during this time of year because CPE is due by 12/31, so we have a large request for those presentations at this time of the year. So he outlined each presentation that he made, as well as trips to this particular office and investigative travel costs, which were minimal. So, but the bottom line is, and I don't think I mentioned this yesterday, this is comparable to our travel budget. There's nothing here that goes above what we had planned for.
Let the record show that's Don Mills, our former investigator.
Sorry, Don Mills. Yes, who's no longer with us.
Thank you. Next item, I think, is the investigator search to replace Don Mills.
Correct. So Don Mills' last day was last Friday, January 13th. So he has resigned to go to work, back to work in public accounting, doing some audit work. So we will definitely miss him. But now we are faced with the fact that we need to find somebody to replace him. So I shared with the committee yesterday my plans for going through this process, basically to post that position on Monday with some modifications that you all had suggested with regard to the job description. So we will plan to make those adjustments, post the position on Monday, collect resumes for 2 to 4 weeks, see what we obtain, and then schedule some interviews. Both Judy Weatherby and Kevin Monroe offered to be the one board member that assists with those interviews. We would, of course, entertain additional board members. However, that would constitute a meeting. So in order to not have to notice meetings for each interview, we will have one board member participate in those. After we schedule the interviews, hopefully we will come up with a recommendation that we can present to this board. This position does report to this board, or serves at the pleasure of this board, and you all have the opportunity to set the compensation as well. So if we are able to make a recommendation in advance of the May meeting, we may call an emergency meeting to do that. If the decision is made closer to that May meeting, we'll just do it at that point. I believe that covers the investigator search. Does anybody have questions or additional comments?
I think of note is that this description and all has been run through legal and through this up the food
Correct.
chain.
It's been run through the assistant commissioner and the HR office.
Further comments or questions? Do you need a formal motion for us to approve the advertisement or
I've been
not?
told you do not need to approve the process.
Thank you.
On NASBA's request to utilize candidate data, we invited Dan Dustin from NASBA yesterday, who shared their request to use candidate data in order to perform a survey to collect data on why individuals are dropping out of the exam process in order to gain more information to try to develop programs that may and try to keep those folks around and continue their process to becoming a licensed CPA. I believe that his comments were favorable, the request was favorable of this board, and you all were agreeable to allowing this. Is that correct?
It is correct.
So I believe we do need a vote on this.
Noting for the record that our confidentiality standards and all have been well covered and that they are not releasing the email addresses, and that this is a one-time survey trying to figure out why so many people are dropping out of the CPA exam process. from day one to the end after different things, trying to find out, a way to fix and be sure that we have a constant supply of candidates that stay in the system if it's something that can be fixed. To entertain a motion to make that approval.
So moved, Don, and I think as part of that, Wendy will have to sign a form that is given to NASBA. I would hope we authorize her to sign that form on behalf of the board.
All right, so your motion is to approve with her ability to sign that, empower the board, to empower her to do it. All right, do I have a second?
Second.
Motion and a second. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
All right, the next item on the Executive Committee's agenda was the summer 2007 meeting date. Over the past couple of meetings, we have discussed the potential of having our normally scheduled July meeting moved to June and held in conjunction with TSCPA's convention. The purpose of that, if I understand correctly, was just to combine those and give more information to licensees as to what this board does, give them an opportunity to attend and see some of the decisions and the issues that this board faces. I did make some arrangements to make that happen, but I believe it was concluded yesterday that there was some concern over the level of interest and the timing in which we could make that work may not outweigh the benefits. Or may not, actually, those problems probably outweigh the benefits. And so I believe the decision was to not move forward with making any changes to that meeting date and go along with our July meeting as planned.
That's correct.
Okay. All right, so we don't need any
We
kind
don't
of
need
vote.
any more further action on it.
No. The last item on the Executive Committee agenda was the update on the proposed evolution of peer review administration. This board previously had reviewed a proposal from the AICPA on the evolution of peer review administration, which made some radical changes to the administration of that program, including reducing the number of administering entities to 8 to 10. Those administering entities would have been required to administer at least 1,000 peer reviews or more. Those were some of the radical changes. Among others, it was noted that these changes would likely preclude our Tennessee Society of CPAs from continuing to administer the program, and therefore our licensees would have to go to another state in order to make that happen and comply with our statute. This board had some concerns over that, and the board drafted a letter, and we sent that in October responding to that initial proposal. It's my understanding that 25 boards responded. In addition, 30 state societies responded with concerns. So there was an overwhelming amount of concerns with this initial proposal. We received just a couple weeks ago, a revised proposed evolution of peer review, which addresses a lot of the concerns that boards had and societies had with this new plan. So one of the notable changes in the revised draft is that they have eliminated the requirement for the number of administering entities that can be out there. It has also eliminated the number of reviews that a particular administering entity would have to administer, and instead it has added some benchmarks that those entities that would like to continue administering the peer review will have to meet. In review of those benchmarks, I noted that our state society is really doing most of those things. They will have to make little change to continue to be able to participate as an administering entity, which is, I believe, what this board was hopeful for. I have talked briefly to Brad and Kara about this. They don't see any problems with the revised plan and being able to continue administering that program here in Tennessee. So at the conclusion of the discussion yesterday, I believe the board asked that I prepare a letter in support of these changes, and I can bring that back to the May meeting for approval. The comment period is June 30th of 2017. Are there any additional comments? No?
Great report.
Okay. And that concludes the Executive Committee.
Thank you. enforcement. Before we get to that, does anybody need to take a quick break? Okay, I see heads nodding, so we can take a 10-minute recess. Still talking.
Sleep.
I did.
Officially call recess the meeting back into order. Cleanup motion that I will need, that I ask our legal team about so that there's no confusion. The motion for Mr. Osborne was to reinstate his CPA license. We also had revoked his firm permit, and we do not want him to have to wait until May, so I will entertain a motion to reinstate his firm permit as well.
So moved.
Do I have a second? Do we need a roll call vote for anything on that? All in favor signify by saying aye.
Aye.
Opposed, like sign. And abstention by Mr. Roberts. Thank you. Enforcement.
Thank you, Mr. Chairman. The committee met yesterday to go over two big things. One was the legal report that was emailed to the entire board earlier this week, which I trust you all have reviewed in detail. I also know that you all were here yesterday during our recap and discussion, so I'm not planning to go in great detail. In fact, I'm just going to summarize by recommendations. I will point out a couple of things, number 13 and 14, some amendments that were made, and also just understanding what you're voting on. After that, we had a brief discussion I'll update the board on, and then I had to leave early, so the illustrious Mr. Elmore filled in for me as the chair of the Enforcement Committee. I'm sure he did an outstanding job going over the status of open complaints, and to the extent there's something the board needs to hear about from that, I trust Mr. Elmore can fill you in. So looking at the legal...
Could we defer discussion of the last comment until later about Mr. Elmore's role?
Sure. Do we need to strike that from the record?
No, leave it in the record.
Okay. So at the legal report, you'll notice on the, I believe it is eight-page legal report you have, the one that was handed out to you today. I appreciate Mr. Reddish and the legal team compiling this. This shows a few changes that we asked for as a committee yesterday, and also the amendments that we made. You'll note that, as has been the case for a couple of years now, each of the recommendations from the legal committee by the type are organized. So, for example, numbers 1 through 4, the legal team has recommended that we close these cases. Number 5, the recommendation is that this remain open, but it is placed in litigation monitoring. Number 6, the recommendation here from legal counsel is that we close the case but issue a letter of caution to the respondent. Numbers 7 and 8 also are recommended closures, but the recommendation also includes sending a letter of warning to the respondents. Numbers 9 through 15, the recommendation is for the board to authorize the initiation of formal hearing procedures with also a grant of authority to legal counsel to settle these cases outside of a formal hearing for different forms of consideration. And I do want to note that number 13 and 14, the consideration for settlement for these cases involves the respondent voluntarily revoking the license. On number 14, the committee made an amendment to the original recommendation. There were two, actually. One is that the consideration for settling this case would require that the respondent submit or enroll in a CPE audit for the 2015 to 2016 reporting period. That was a change that we made. And also we reduced the payment from $1,000 to $500 as another condition of settlement. So those were the two changes that came out of the committee discussion there. Number 16 and 17 on your report were given to us, and the recommendation was for us. I meant 500. If I said 5,000, I apologize. That's a good catch. So on 14, we reduced the recommended penalty from $1,000 to settle to $500 to settle. Thank you for catching that. Number 16 and 17 were recommended to the committee to discuss to see if we had a recommendation to make to the board. We discussed them. You all were here for that. The number 16 really, as it boils down to it, is a dispute between two parties who are or were in the middle of a divorce at the time. Our recommendation here is to close this and not do anything further with it based on the facts and complaints that we've received thus far. Number 17, there were allegations of crimes by the respondent committed against the complainant. Whenever the allegations surfaced, the individual ended up, the respondent filed bankruptcy. It came to our attention during the investigation that we had already, as a board, revoked the license and permit from the individual respondent, and so there's nothing more we could do. That was the strongest form of punishment. So the recommendation that legal counsel here wanted us to discuss as a committee was a formal referral to the local district attorney's office for this case, and we agreed with that. So that was the outcome of that discussion. And then items 18 and 19 were representations to this committee and this board. We had heard these before. The recommendation for 18 is to close the complaint. The recommendation for 19 was to close the complaint and issue a letter of warning. And so the committee agreed with all of that. So on this new report you have in front of you that has the various blue text showing updates from the committee's discussion, the committee recommends to this board that you accept the amended legal report and all of the various recommendations from legal counsel that are included in that report.
Thank you. Do I have a second to that?
Second.
We have a second.
I would also like to thank legal for the highlights. That's very, very helpful.
Thank you,
That's
ma'am.
very nice. We like you doing that.
And there are no abstentions on any of these cases?
That's correct. Nobody disclosed any conflict of interest.
Thank you. Have a motion and a second. All in favor signify by saying aye.
Aye. Aye.
Opposed, like sign. Motion carries.
Mr. Chairman, the discussion that we had prior to me leaving was that we had asked if legal and or staff could somehow get together and by the next committee meeting present some ideas on how we could, without being too administratively burdensome on the staff or legal, come up with a way to index or categorize the types of penalties that we have authorized in the past as a board for the various types of complaints that show up in these various groupings that we see in this legal report, so we can know from a consistency standpoint, instead of having to ask and put our staff on the spot, we kind of know what we've done in the past, and if there's an outlier that's presented to us, we can easily understand that, identify, and then ask the questions as to what we think it would. I think it would potentially make it a little more efficient, but I think more importantly for the profession, it would provide some consistency in how the enforcement committee decides and makes recommendations to this board for punishment. And since you all rely on us to do that, I think that would be helpful to us. So we're not looking for a lot of work from them, but they said they would go back and look and see what they could do. I know that Mr. Reddish said that some other boards do effectively a fee schedule. I'm not sure if that's where we're going to go or not. It may not work on this board setting, but we anticipate getting some ideas from them by the next committee meeting, whether that's actually some type of draft report or if it's just, some ideas they had based on their work. So we look forward to hearing from that. And then, Mr. Elmore, is there anything to discuss with the board on status of open complaints, or do we actually need to go through that report with the board as a whole?
Pull your mic down, please.
It was that extra one page that.
The representations?
No, it was the one where it talks about the different complaints that have been opened and closed, et cetera.
Wendy did a good job of covering those, and there were no there was one question I recall is the difference in the 40 is showing here and the 43, and there were 3 new complaints that originated after the end of the year. So that was our discussion.
And y'all may have discussed this, but has there been a noticeable impact on the ability to compile legal reports when we don't have an investigator? Have we felt that yet?
We haven't really felt that yet. Don was able to finalize all of the cases that he had been assigned, which was a good thing. I believe we have less than a handful on there now that need to be assigned to an investigator. So we're in a decent position. Obviously, you never want to go too long, but I think we're okay at the moment.
Mr. Chairman, unless there's any questions, that concludes the Enforcement Committee report.
Great report. We appreciate your work and the ideas that you all brought forth.
Should we consider giving Wendy the permission to, if these legal issues are if there's an investigation needed, so that she can proactively get someone to help from the pool? I think you said resource pool. Do we need to?
You already have that authority,
yeah,
don't
we
you?
already
Do you
have
have
that
that?
authority.
Okay, good.
So what the legal team will do is as they review cases, if they feel like it's something that the internal pool investor can handle, meaning a non-CPA, let's say it's a unlicensed practice case or it's a peer review, were you in or were you out, that are fairly simple to gather evidence on, then we will let the pool investigator handle that. If it's lack of due professional care, most likely we'll have to hold it until we hire an investigator.
Okay, I just wanted to make sure you didn't have to wait until the next meeting to have the approval.
Thank you.
Good question. Legislative review, I'm not aware.
We've been told that we need to include this, but I am not aware of any active legislation or proposed legislation that would involve our statute.
Thank you. So noted. Under old business, accounting license database, the ALD, we have some attendees here from NASBA that's going to enlighten us, and Wendy's going to introduce would you like to introduce our friends from NASBA on the ALD?
Sure. Do you want me to give a synopsis?
Give us a synopsis, and then
Okay.
Then we'll have them here for questions.
Okay. So at the last meeting, I brought to you all a request. Basically, there is a national licensing database called the ALD, or Accountancy Licensing Database. And we currently feed over licensee information that includes the status of their license, the individual's name. And what this does is it helps various boards be able to see where individuals are licensed throughout the country and the status of those licenses. So they are increasing the information that goes into this particular database to help state boards gather the information that they need. So one of the requests at the last meeting was for us to add our discipline to that particular feed over to this database. And part of what precipitated this was that California introduced or passed legislation regarding individual mobility, which called for a determination as to whether other states were considered substantially equivalent when it came to enforcement practices. NASBA worked with NASBA in order to gather this data over a significant period of time. Individual boards completed, myself included, surveys as to how we handle complaints and enforcement actions and those types of things. And in the end, we were considered fine in our enforcement-related actions, but we do not supply our discipline to the database, and that is one of the things that California is interested in, or has determined to be part of the substantial equivalency with regards to enforcement. Now, this discipline could be just in the form of a flag, or it could be detailed information about any discipline that we have assessed against a licensee. So at the last meeting, you all had some conversations and were concerned about this and ultimately voted it down. So One of the things that I was inaccurate about in my explanation, and there may be more, but the one thing I know for sure is that I indicated that all discipline would be fed over. And one of the concerns here that was discussed was that, if somebody failed a CPE audit 20 years ago, you all were not so comfortable having a flag on their record, maybe for the rest of their life, regarding that. One of the things I understand subsequently, after talking to Maria with NASBA, is that may not actually be the case. They are looking for more practice-related discipline. So what I thought was probably best in my discussions with Maria is maybe they ought to come over, explain their ask a little bit better, give you all a chance to ask them, and make sure that you're getting the accurate information and ensure that the decision that you made is what you want to stick with, or if you would like to change your course of action. So I'd like to invite Maria Caldwell and Stacy Grooms. They are both with NASBA, and up to the podium would be great. And if you'll make sure that when you talk that you hit the speak button so that it's turning red. There you go.
Okay, great. Thank
Perfect.
you.
Thank you.
Thank you for inviting us here to talk to you about the ALD and the enforcement project that really is wrapping up in the next 2 months or so. So a little historical information about the ALD, and the ALD is internally used by board staff that are authorized by a particular board. There's a public-facing version of it as well, which is CPA Verify, which has a much more limited subset of information, but it's available for free to the public to look up a CPA to see their license status. They're linked across state lines, so if you have a license in Tennessee and a license in Missouri, the public can see that you have 2 licenses and the status of both licenses. So if you were revoked in one state and you don't tell a client that, I used to practice in Missouri and I was revoked and here I'm in Tennessee, they can see that for themselves. So it's the CPA Verify public-facing version of that database that is at issue with the California Mobility Project. And the NASBA, since we started with this project with the ALD, has requested that boards send their disciplinary data, and we've been keeping up with that. A lot of times in the beginning, when boards early on in Tennessee participated in the early days, their own databases from which the feeds came didn't include disciplinary data, so they couldn't send it over. So we continue to work with boards as they upgrade their databases to get better and better information, because it helps the boards as they interact with each other, and it really helps the public to understand what the status of the CPA license is. Additionally, the one difference between the 2 databases is that the ALD has details of what the disciplinary action might have been. The public-facing is just a flag. If the board sends information about discipline to the ALD and there is discipline on someone's record, there'll be a flag that says, call the board for further details. And then the board is at a leisure to give as much information or as little information as they're allowed to within their own statutory structure. So with that being said, we are winding up the review of all of the boards. Thankfully, all 55 boards were determined to be substantially equivalent to the guiding principles of enforcement, which is great news for the profession and for our regulatory boards. 9 boards did not have disciplinary flags available publicly, and we are working with all 9 boards. They've all approved, save Tennessee, to include the disciplinary flag. Several of them just have technology issues with getting that data over to us. So some of them have to update their feeds to the ALD, and then those that don't have the ability to do that are going to send the data to NASBA in a spreadsheet form, and we've come up with a technology answer to insert that data into the records. So our ask is that, and I guess to address one of the concerns that the board had last time, really what the legislation in California when they passed mobility was that there be a publicly available discipline flag for major discipline, not administrative law type or administrative complaints, really practice, ethics, really the bigger violations. So that is the kind of data that we're looking for, not the whole host of things from, scale on a 1 to 10. We're not looking for the ones. They're looking for like 6 to 10. And I'd be happy to entertain any questions if you all have any.
So will that, Wendy, how do we compile that data? Do we have it so that the only flags that'll show up to the public when they look at this database are the more substantial problems, or?
I'm not an IT expert. However, I think it's going to be a bit of a challenge. Our records are coded, so individual's license is coded by if discipline has been assessed. So that's anything from any type of consent order, whether it be for failure of a CPE audit or due professional care. So either way, they're just flagged with discipline's been assessed. It's not the type of discipline. So it will be a little bit of a challenge from an IT perspective to only feed over certain types of data. I'm not sure how we would be able to capture that. We would most likely entertain a whole host of IT experts in order to help us with that. And it may be that we're one of the states that we end up having to do it in a spreadsheet type format. I'm just not sure at this point.
I think the I think the objective would, or I think what we would definitely not want to happen is for someone to some kind of administrative type problem, and then them have this red flag when the public looks up their.
That's my concern is the parameters for which we report these individuals.
I understand.
There's really no control over that. I mean, it's kind of, who's to say that this administrative error that she's referring to is different from a different type of enforcement activity that we've done against a professional? I'm concerned as to how this information is going to be used, how long it stays in the public view. It's a blacklist, and I mean, it's going to be used as such. And I'm not sure I'm comfortable with this board being a part of that. Now, I don't know if the society has any comments. How do you feel about it, Brad? I'm curious what the society thinks.
Well, our concern was the same as yours. The more egregious violations, practice violations, ethical violations are one thing. If someone's 10 days late in renewing their CPA certificate, if they're going to get a red flag for that and flags all look alike, that's a concern. And we don't have an appetite this session, by the way, to do that quid pro quo legislation, but I understand your concerns, and I think that...
Well, now we're asking staff to make that assessment, too. And so that is even a bigger concern as to how...
Right. It may take a little extra work on the board staff or NASBA staff to make that work and to get that information right, but the more egregious stuff seems to be reasonably shared with another state like California. And our concerns are the same as yours. Yeah.
And my other concern would be this, is California, you talk about mobility. Is California passing mobility equivalent to our state's mobility rules?
From an individual perspective, yes.
What about firm?
I'm not sure if I don't think California has firm mobility yet.
They don't have anything.
No. So this is all about, and honestly, we could talk about it as a California initiative because it was in their statute when they passed mobility to have, and their legislature passed it, that the California board do this determination of enforcement, because really, but it served the interest of all of the boards doing this, because every state that has allowed CPAs from other states to come into their state, you want to make sure that the enforcement practices of those other states are up to snuff so that the bad apples aren't coming into your state and doing harm to your public.
Can't we do that already?
Excuse me?
Can't we do that already?
Can't you do what already?
Can I not find a bad apple? I mean, if somebody comes and applies for a license in Tennessee, are you saying we can't call those boards and find out if they're...
Oh, you can call, but with mobility you're not applying. So the ALD has a lot of uses. One of them is when there's somebody applying that's a reciprocal license, for the board not to even necessarily have to call the other board because they can look at the data.
And we participate at that level.
Yes, you do. And so this is the public-facing version of it. And I completely understand your concern about having too much discipline in the whole range being flagged in the system. And that's not our intent. And even with respect to Tennessee, I think you publish your orders. And one of the things that when we were looking at this, as we were going through this process and realizing that some boards just didn't have the data in electronic format, and that would be a burden on the board to have to get it into that point. We have in our budget resources to help with that effort, to look at the public, the public records and digitize it in these spreadsheets, that way we can upload it if your system doesn't flag it with enough granularity to get only the ones that we're really looking for fed over. We can work with the board to help digitize that data, make a determination of which should be included, have that one kind of historical upload, and then on a quarterly basis we'll just check with the boards to see if you have any discipline issue that meets that criteria, and maybe that can be part of when you do issue discipline at that level, approve for it to be sent over to NASBA to be included. So I think there's a way to get to where the public is protected, but CPAs aren't slighted by having, a long time ago administrative complaint mar their record.
Is this, I don't know,
Go ahead.
is this a NASBA project?
Well, I guess the ALD is a NASBA project, but it's a NASBA project because the boards of accountancy wanted it. And it really goes back to the days when individual mobility was being discussed, because there was concerns about CPAs moving around the country, but the public having no idea what their record was, what their license status was. So the boards are really very forward-thinking at doing this concept of centralized data. It's only the CPAs and nurses that have a national database of this type, and the nurses have it because it was federally mandated. So it really is a very helpful tool to the boards and to the public, and there's a lot of other opportunities we'll have in the future to match data. For instance, there are now records available from the DOL about who's submitting audits, and with that data is an EIN number. So if you have states that have firm information included in the ALD with an EIN number, we'll be able to start reconciling that to allow you to know who's performing audits from your state and whether they're enrolled in peer review as they should be. So there's a lot of power to it.
I guess I agree that there's obviously transparency is good. The issue I think we all are concerned about is that data used for comparative reasons is only good if there's integrity in the data and it's consistent. And your comments earlier were helpful, that you would work with us and work with the states to come up with a way to figure out what level of granularity is worth reporting. But that seems like a one-off approach, and I guess my question is NASBA committed to doing a one-off approach with 50 states plus other entities? And more importantly, wouldn't it be better to have a standardized submission form instead of a one-off approach where
Right now, most states of the 55 that will be participating, at this point there's only 5 that need to send a spreadsheet to us to be uploaded. The rest of it is coming directly from their license system into our system.
I'm talking about more substantive than procedural. So if we have a reporting mechanism in Tennessee that gives a flag that Brad was talking about for everything, whether you're 10 days late submitting a license or whether you've committed fraud against your client and been revoked and had a felony charge and you're in prison, right? If it's all the same, but another state, Iowa, I don't know anything about Iowa, but if they have one where they only report the really egregious things, and then a state like Mississippi that only reports, for whatever reason, the things where you're late 10 days doing you're going to end up, I think it's great, and I have full faith in the Tennessee practitioners to be able to say from a competitive advantage, come to Tennessee and let us be your practitioner because we have mobility. But if that data can be used in any way against our practitioners, because it's misinterpreted or because the data is inconsistent across states, et cetera, I don't think that's something that this board, in my opinion, that we should be willing to do, because I think that harms our practitioners, and the harm is way bigger to our practitioners than the benefit would be, in my opinion.
But I think in your situation, while we did try to create as many standards as possible with the ALD and what states want to send, we leave it up to the states on what they want to send. So there are several states that send everything because that's how their state operates. They've got a lot of Freedom of Information Act information, and they're willing to send everything, and that's how their state operates. In your situation, you'd be sending the smallest subset, so your practitioners will probably be at least risk for misinterpretation of the data because you'll be sending a small subset, and it'd be maybe practitioners in other states where they send everything from soup to nuts that would be at a disadvantage.
Well, the other piece for our legal is, can we even, I would think there may be instances where people go through hearings and they, for whatever reason, they may be under seal, even if it's in court outside of our jurisdiction. Can that data even be provided? And if so, then perhaps you have the most egregious folks who deserve to be told on, for lack of a better phrase, who aren't being told on.
But I get back to the point. We are already participating at a level in which we state the license is either active or revoked. People know on the database right now what the license status is. What they're asking for, what they're really wanting to know is, what'd you do?
Yep.
And I'm not comfortable with that.
I agree.
So I'm going to be on record as saying that. I'm not comfortable putting the type of actions that these people did. I just don't want us to be in a position to do that.
Can I ask a question?
Yeah.
I think I remember that Tennessee posts the orders. Is that true?
You
No.
compose?
No?
Some orders are uploaded through the University of Tennessee at Knoxville's library database. Some of our final orders, and those are going to be ones that go through a full hearing that are public record. Those are categorized. And I do know from my previous employment that there is an effort to make administrative orders available through the Secretary of State's website. That has not happened. They're way early in that process. It would be disingenuous to say I would even estimate a timeline for that. But in the future, it is true that there is a movement towards making the final orders issued by administrative judges in this board available to the public. And I don't know how that would be incorporated in our current Verify system as is.
I think there's probably a lot of questions that have to be resolved at the AG's office, because my agency has the same issue, and we have a lot of hearings in front of ALJs where the question is, even if they are considered public record, is there still a duty on the state to redact certain information? And that's unclear. I think that's still a question. So, I mean, your point's well taken, but I still think that if we're going to, getting back to Mr. Watkins' point, if we're going to do this and potentially harm our practitioners, I think there needs to, frankly, a lot more work at NASBA level, if this is a NASBA project, to come up with a standard way of reporting the what did you do and making sure that it's apples to apples, because otherwise I think that's a disservice to our practitioners.
Well, we can most definitely send a report of the types of disciplinary flags that the current 51 that are participating send, and what we're requesting for the balance, because there is a range, and it's all acceptable. And if you want to be on the shorter end of the range to protect your CPAs, there has to be a balance between protecting the CPAs and protecting the public at the same time.
And again, I get back to the point of, if somebody's done something egregious and this board has come before this board, their license is going to be revoked. And that ought to tell people something.
Right, they're revoked for sure, but there's times where your license has been disciplined and it may be revoked and reinstated, or it may be suspended and reinstated, and then the status does not match your disciplinary history.
Well, I don't know. I think if people have made their atonement for what they've done and they're back to active status, and we had a case this morning with that very issue, I don't know how far that should follow those individuals. But if we feel like they're back to being capable of practicing in the profession, they've made whatever atonements they've made, and I'm not comfortable with this process. I'm okay with the fact that people can verify an active or revoke status license, but I'm not comfortable saying this is what that individual did. If that stuff's out there on our stuff, that's fine. I have no control over that, but I don't think we should go out of our way to provide that information for that process. That's my personal opinion.
I agree. I think it kind of undermines the board's process that we go in and evaluate a person who's committed a wrong and give them the step, we either revoke their license or we give them the proper steps to get back in good status. And when they do that, to me, that's in the past. We've decided that they're fit to practice now. This is a blacklist. I mean, it's going to follow you around forever if you make a mistake in your past, and then if you've got a competitor that's going to come out and say, "Don't use that guy. He's look what he did 20 years ago." I mean, there's a certain thing in the law for committing crimes. What is it? Being expunged. I mean, you have things taken off your record. I mean, I think that's the concern I have, is it's going to follow you around the rest of your life, and there is a certain need for forgiveness, and people change. I mean, that's my biggest concern there. The other question I have is this a California push, or you said California is not pushing this issue, or?
California, when they passed mobility years back, part of the statute approving mobility was that there be this review of the other boards of accountancy to see if their enforcement practices were substantially equivalent to California's. And within that legislation is a standalone requirement that there be a public flag for discipline. That is equivalent to, because really what will happen is if a state doesn't have a public flag for discipline, that's equivalent to when they were back in practice privilege, where you filled out a form. On that form, you would mark whatever discipline you had in these certain categories. And so they're just trying to equate it to what it was before to currently. And that's what I can go back and do some research on and see exactly what those specific items are, and discuss it with Wendy on your discipline, and if it's really just about people that have been revoked, if that equates, and see if there are other states that are doing the same thing, so that we can get to where you all are comfortable that you're not putting the CPAs in harm, but we can get to a place where the public's not at harm either.
You mentioned that the nurses nurses and accountants were the only ones doing this? Is
But with just having a national database.
does the legal community have that? I would like to know that. I mean, they don't have one?
They don't have a database that the different bar associations share amongst themselves, like the ALD.
They publish censures and disbarment activities and things like that, and bar journals and on the boards of professional responsibility. So, you can go back and look and see things, but I think that's probably similar to us. Again, I just want to go on record as saying, and I appreciate your comments and I appreciate your advocacy for this. Nobody here that's talked that I've heard doesn't want to protect the public, and we're doing it. We're not protecting the public at the expense of protecting the practitioners. The point is, if the data is inconsistent, not only is it disadvantageous to the practitioners, but it's also not helpful and useful to the public, and in fact could harm the public, leading them to a wrong conclusion. And so our only point is that if NASBA really wants this, it seems like NASBA would do the work to figure out a way for the gradation of violation that you're reporting. You figure out a standard across all states, which is going to be difficult because every state has different open records laws, and figure out what is the minimum that's acceptable among all states, and then try to get us to coalesce around that. I just want to be clear for the record that nobody here is trying to protect the practitioners at the expense of the public.
But that's what.
And again, I will say this: if someone comes back into good status with our board,
right,
you're basically saying to us, "Well, that's not good enough." I don't know if you catch that, but you're saying the public is being harmed, and you've got to protect the public.
Yeah.
If we allow that practitioner back into our profession,
right,
we feel like they have done what they've had to do to get back into good standing. So the public should not be harmed. Otherwise, we would not allow that individual back into the profession.
Exactly, and that's what we're saying. We've left this, as much as you want to have the NASBA make standards for everybody, the one thing we're very appreciative of at NASBA is that there's 55 boards, and they are all different, and one is not better than another, and one structure is not better than another, that they're ultimately the determination within their state for their licensees and the public within their state. They're in control of determining what is appropriate and not appropriate. So with that being said, the ALD committee, which is really the committee that made the determinations of what should be in the ALD, what shouldn't be in the ALD, when we decided to launch CPA Verify as the public-facing version of it. That's why there aren't details there. That's why there's not specific information in that field about discipline. It just says contact the board. Because then the board can say, it was nothing, it was a CPA violation. If you're a board that's sending, say, from 1 to 10 of violations, you can give that information out, or you can tell the whole story. It's also up to the Tennessee Board to determine if you reinstate somebody and you think that clarifies any issues with public harm, that data then can get changed, right? So when they get reinstated, you wipe off the disciplinary record.
But we don't have control of this database. This isn't our database. How do I know somebody's going to wipe that information out?
Well, because it comes from the state. The state sends the feed, and we don't touch the data along the way. It just comes.
But it's already in the system.
It's already in.
You're having to delete stuff from the system, and that's not going to be us.
No, what happens is boards send the feeds every single night for the most part. Some are on a quarterly basis.
Data goes in.
And it goes in. And then the next night, so today you have somebody, if you revoked somebody today, and in their database, in your database it changed, and the feed comes over tomorrow, it would take that person's status from active to revoked. If there was a disciplinary flag, not yesterday because they were active without discipline, and then you revoke them and they had a disciplinary flag, tomorrow it would change. If 2 years from now, you reinstate that person and in your database wipe off the disciplinary flag and move their status back to active, it comes in overnight and it instantly is back to active and no disciplinary flag. So you control the data because you're sending it to us, and it overwrites whatever the data is. Otherwise it wouldn't work, because then when you're revoking people or adding people, when there's a whole crop of new licensees come in, overnight that comes and it populates them both into the ALD and the CPA Verify.
I'm not trustful of the IT process. A lot of stuff goes across the internet that's being tracked daily, hourly, by minute. I don't feel like if every day that database gets wiped and a new database gets put into place. I just don't believe that.
Well, I can assure you that's actually how it works.
Okay.
But let me speak to it just a moment here. I spent some time in the ALD database. Got to log in and spent some time searching. In front of me, and I looked at, number one, I pulled up a couple of people that I remembered the names on, somebody that actually used to work for me, and I was, that we disciplined in Tennessee, but he actually must not have ever had a Tennessee license. We were disciplining for function without a license. Well, he's flown the coop. He's in Kansas now, but his Virginia says he has an expired status. And, if we took those sorts of disciplines and were able to feed them into somewhere that we had in Virginia, I would have to say that's protecting the public, because nobody can look at it and see otherwise.
We're doing that now.
No, we're not.
Aren't we?
No, because he's not a licensee. We had to go back to our disciplines to even find him.
But whoever is in our system, we have reported their license status.
Right.
That is correct.
Expired,
so if it changes to revoke, just like Maria was just, and so Mr. Osborne this morning, you all voted to reinstate his license. Once I do that, the next day he will show as active on the ALD, verify wherever.
Here's a Kentucky one, for instance. This says that there was a violation. The status is closed. They have an active license. The date it opened was January of 14, and they closed it. Description of violation just has a code on it. Contact the board for further notice. And that's exactly what California said. I found very few in here that were feeding thing other than the fact that
And Virginia is one of the states that does not currently have a disciplinary flag, and they're working on digitizing their data to send it over. So that's probably why there's not additional.
Virginia, D.C., and Maryland and Tennessee do not. Kentucky just says see, view record for detail, and then when you go to the record for the detail, it tells you that it was open and closed on particular dates. Contact the board.
One thing I would like to, just in Trey's description of what problems could be, this board considers past actions when we're making a decision. We want to know. Just yesterday, we asked a number of times, have they had any prior discipline? This seems like a good idea to me, I guess I would say, and I'm more trusting of if there's the right security in place, and from everything I've seen, NASBA is
on top
excellent and on top of that sort of thing. So I, for one, think it would be helpful. I look up things on the internet all the time about, licensure and, whatnot, and I think it's helpful to the public to be able to see that kind of thing, and we can determine how much history is there, or when they need to contact the board, and I like the fact that what will be reported is Mr. Osborne is now active, and it's not going to show.
No, but what they're saying is you got to tell him what he did.
But that discipline would remain on his license for however long. In our records, it stays there forever, so I don't know how it would ever get removed.
Wendy, that would not be in the public portion of this ALD, right? It would be in the non-public. And
it would be either. The public record will show what you decide to send to it as a board. So if you make a determination that when someone gets reinstated, their discipline is no longer public information, then that flag would change.
So
it's really up to the determination of the board, the scale of.
Okay, that and I'll let legal speak to this, but that's another one of my concerns where we pick and choose unless we have an extremely standardized process that we can give to the media, whoever is going to question us on this about how we're deciding. To me, it's either you're doing everything, or if you're going to pick and choose, it has got to be laid out specifically, or we could run into legal problems.
One of the hesitations from a legal standpoint, I wouldn't say hesitation. I don't want to influence the decision of this board at all. But I would agree with Member Roberts that we really want to have a very clear guideline of what is going to be disclosed, because under our current Open Records Act, if someone were to call this office and request information on that license, because of the way our database works, that discipline, regardless, will be flagged, and they will be able to access that information. But if we say we set a different cutoff because we don't want a discipline under a certain degree of severity on this database, there will be it could create an inconsistency. Because if people are contacting us directly and requesting those records, our core system will always reflect that discipline. But if this board wishes to limit the discipline that's available through this database, consumers will see different information in the ALD than they may receive if they did an open records request with this office. And in addition, for staff's purpose and legal's purpose, we would want extremely clear guidelines so that there's not going to be a discretionary decision on staff on the severity on a case-by-case basis. So that way, that we don't run into an incident where one licensee is reported and another isn't, and they feel that the discipline is parallel.
See, I get uncomfortable because if somebody's in good standing with this board and they see a history on this database, another state board, they get maybe their license rejected. And we've prohibited them from getting further work wherever they're going. And I think that's a real problem.
I kind of cut off a minute ago because I had a question of you on the non-public database.
Mm-hmm.
That's not a NASBA project really as much as it is something that the individual state boards wanted and would find useful. And so NASBA is accommodating or helping with that process. Now, that's what I heard. Am I correct in that?
Yes, that's exactly.
The second point I'd like to make is even yesterday as we were discussing one of the applicants for reinstatement, the question came up about revocation of Kentucky license. I mean, it seems to me that this non-public database would assist all of the 55 different states in answering those kind of questions. I mean, somebody had the question, so it must affect somebody's decision about whether to do the reinstatement or not. The last point I would like to make is I understand your feelings, Trey, and respect those, but I feel entirely different about that. I think if somebody has been disciplined, that's relevant. And the fact that they know that that's going to be in the record permanently, I think it ought to follow them. I think it ought to encourage people to follow the rules in the first place. You don't follow the rules, one of the penalties is your record reflects you did something wrong. And it reflects it for a long time, but
it may be forever. And
I think that's the way it ought to be.
But if that's the case, then we shouldn't be reinstating somebody's license.
I don't agree with that. I think that if they've met the requirements to get reinstated, we can do that. But that does not change the fact that they did something wrong in the past.
And it's available. Our state board has that information. I just don't know that we need to be putting that out there.
Well, and the concern for I think that's a very valid point, Casey, but my concern is that if you had 10 people and they all have some type of violation, as I understand it, at this point, it all looks exactly the same, whether it was stealing from a client or being 10 days late, as Brad said, renewing your permit. And while I do think there's something to diligence and detail-oriented nature that I would want from my accountant, even preparing my taxes, much less doing a test engagement, so that they don't miss the deadline to renew their permit, it clearly isn't exactly the same thing as somebody who's stolen from a client. But if they're presented as the exact same thing, that's to me where the issue is, because what's going to happen then is that our folks, because if we in fact are doing this and we overshare, for example, then our folks are going to be at a competitive disadvantage to the people in Kentucky or Mississippi or Alabama or wherever that they don't do that if they have some level of gradation. And my only point is the database, in my opinion, is completely useless. It doesn't accomplish the purpose that we're talking about unless you can have a standard way to compare apples to apples about the various flags. If everybody who is late 10 days across the country are showing up as they were late renewing their permit, totally cool. If everybody who's, committed some type of terrible sin against their client is identified as such across the country, totally cool. But if you have some state that separates that, or some state that doesn't report anything, and Tennessee who reports everybody is exactly the same and they're the equal center, I think that's harmful, not only to our practitioners, but to the public.
And no flag doesn't mean the same thing across states. So if one of the key uses is to filter who's good and who's bad, then some states would report that person as good and others would not. So I guess I'm surprised at the lack of desire for standardization. And if you're collecting all this data, because I do see a usefulness of it, like Casey, why not collect it specifically so that people can interpret it better.
I think the thing that I would look at, pardon me, from our perspective is, I think our board is just as interested as most of the boards in the other 54 jurisdictions about protecting both the public and their practitioners. And so I don't think that's unique to our board's desire to do that, and I agree that we do have it and should. But I also know from, having worked with the Nebraska Board of Accountancy and the Iowa Board of Accountancy, the Virginia Board of Accountancy, that, I think we're going to have some discretion, as it's been described, as to what we would choose to report, and we'll have some work to do to make sure that we stay in keeping with our privacy laws. But I think we can tailor that. Now, that having been said, I agree with the notion that we have a lack of consistency amongst the reporting entities, but I'm also worried about being the one jurisdiction out of 55 that, in essence is going to penalize from a mobility perspective its practitioners by not, to some degree, cooperating under our terms with the information that would be provided, because I think there is potentially some harm to our practitioners in that manner as well. I don't like to jump to California's beat any more than anybody else does. But I also think there is a way forward that can be, where we can minimally meet the criteria that are required for participation without sacrificing our judgments and our jurisdiction. And I would like to see us at least attempt to move in that direction.
I would add to that and say, as much work that has been done on this, it would be pretty easy to actually add like a special code and set this up from an IT perspective, so that there is a list and this number means this, and and then it meets all of the requirements that Gabe and Trey are talking about. That, to me, is a very simple thing to solve. You just have to get each state to buy into it, or
standardization is a goal of NASBA since its inception over 100 years ago.
Yep.
At the same time, we have to respect the fact that there are 55 boards with 55 different sets of rules, from freedom of information to sunset to privacy to confidentiality, and every board thinks their board and their rules are the right ones.
Yeah.
In addition to that, there's also resources available to the boards. So there are boards that are very well funded and have a lot of IT resources at the board level that control their own universe, and they can make any changes they want in their own database so that they could address something like that very quickly. There are others that are under umbrella agencies. They don't control their data resources. So if we come to say, well, NASBA requires you to create in your own licensee database all these new fields with all these new statuses so that you can change your feed to just send these, they don't have the control to make that happen. And that one little change is not a priority for the state of, name the state of Pennsylvania, that's a big umbrella agency. So it gets on the ticker for IT requests to be done. And believe me, I've been living this for 10 years. The fact that we have almost 55 boards participating in this has been not only an achievement to the boards in understanding that, sharing data amongst each other as regulatory boards is great for the profession and for the boards, but that they were able to champion those resources and all the disparate kinds of databases. It's not even like everyone's using the same platform. So there's been a lot of, I've learned a lot about technology. I'm a lawyer by trade, but I've learned a lot about technology through this effort. So I completely agree with you, and where we are today with the ALD and CPA Verify is not going to stop. Standardization would be great as IT resources get, easier to use and maybe boards have more control. We'll still champion that thought. But what the ALD committee came up with to address all the concerns that have been said here is to have the flag say, contact the board. Because then the board can tell them what the board would tell them if they did a FOIA request. So that's really we thought, the best case scenario to address disparate 55 versions of the truth.
I think that opens up a lot of concern. If I'm you've got a competitor in there, and I'm bidding on a client's job, and I go in there and say, don't do business with that guy. He's got a red flag on there. Nobody's going to contact the board and go in there and spend the time. They're going to say, oh, black flag or red flag, whatever it is. I'm not dealing with them.
Keep in mind, this is not on the public database,
But
right?
it's got a flag, though.
Let me tell you what's on the
Flag
public
would not
database.
be on the public, right?
The only flag that's on the database says contact the board for details.
Oh, well, yeah, that's.
I mean, it's a flag.
Let me speak to one that is in case in point into what we had this morning. This is a Florida one I had pulled up on the ALD. And I pulled this record from, I think I came up with this name from an IRS newsletter that they had pulled their license, whatever, or they had disciplined, and then Florida evidently pulled their license. On ALD, it said voluntary relinquish, active now. So you know there's been a disciplinary proceeding in the past. If you're going to hire this person and you want to look them up, or you want to hire them as your accountant, have they had problems in the past? And then it says view record for details. And then when you go to CPA Verify the public, it has exactly the same thing. And when you kick on the details of that, it says license relinquished and can no longer practice public accounting. This may or may not have been a result of disciplinary action. Please contact the board for more information. So all this is doing, it's not telling you any details. Now, if I Google this person, odds are in Kentucky, Virginia, they spend big paragraph forms in every disciplinary proceeding, whether it's CPE audits or not, that's published, and you can pull them up on the internet. We do a very similar thing in our state board each month. If you'll go look at it, they publish the disciplinary action as it's signed off on, so we have something virtually all 12 months showing up on the internet in published disciplinary report. So this ALD Verify or the CPA Verify, whichever one you're on, doesn't have a lot of detail. It just says there's disciplinary action out there, contact the board. It's not saying that they're, and if we don't want to send the administrator because you're late, then so be it. Let's get the IT department to fix that. It's only, and that's will take some time. But there again, if particularly going forward, and we're going to be going through disciplinary actions already for the past little while for the sentencing ideas that we would have had, or fines, etc. It'd be just as easy to capture those sorts of things to provide it, because I full well believe that with the profession we've got, we need to provide a consistent basis that we're comfortable with. And I certainly don't want things out there, but in the case we had this morning, that was, somebody looking at that situation. He's brought his things back in line, but people need to know that. Now, they can go to the internet, but why should they have to if the licensing body has it as part of a database that is open to public record anyway?
I promise I'm not trying to be difficult here, but I mean, that while that somewhat alleviates the concern, I guess, the two issues. One is, if we're saying we're going to do something that's consistent with what we're comfortable with, and 54 other jurisdictions do that, by definition it won't be consistent. And the second thing is, what benefit does it provide? If what legal counsel said was, if you want to look up a CPA in Tennessee, just contact the board. You go to a website and type their name and it says contact the board. I mean, I don't know how much it's going to cost to do this, but I mean, I'm assuming NASMA's not paying for that. What benefit is it? It's just another online aggregator of data.
And it tells us if the license ever been pulled for one reason or another.
You could contact us to do that anyway. It's telling you, come to Tennessee State Board to figure that out, because we don't have that information. So if I could just avoid that step and go to the Tennessee State Board, if I'm doing work on my house, I check out my contractor. I go to the contracting board, I figure out what's going on. If I move to Mississippi, I'm going to look at real estate agent and make sure they have a license. Like, I'm going to do that, right? I think anybody that's going to...
Are you going to look at that real estate license and see if there's ever...
I'm going to contact the licensing agency and see if there's any issues, yeah, which is exactly what's going to happen here, because you're going to go to this website that promises to give you all this data on somebody, and all it's going to say is, Gabe Roberts, he's got a license, there may have been an issue, contact the board. Why don't I just skip the step and contact the board to begin with? I just don't see the value.
I've hired a bunch of people over the years, and I have never contacted the board to check out a license. And maybe that's my own shortcoming.
Check out every attorney that I hire to make sure that there's not some issue. But I mean, that's just
on the website just to see if they're active or not.
Oh yeah, no, absolutely.
So I mean,
we'll go there.
If they're active, that means they're okay. If they're not, there's probably a issue to contact the board on our website. Even though it
But how do I
doesn't
know
say
if they come from somewhere else?
Who?
If they're moving into the state? We verify that they have
I
a
go to
current license.
Mississippi and
You can look it up in Mississippi.
look up their stuff.
I mean, I guess the point is that you can confirm the license is active. The point is you're not going to get any details unless the state decides to provide those details to the ALD, as I understand it. And we get back to the consistency point where if California does it and Kentucky does it, but Mississippi doesn't, and we decide to do it, well, does that give people living in South Haven a competitive advantage at the expense of our practitioners? I don't know. I mean, y'all are the ones that practice it. And I may be beating a drum that doesn't need to be beaten, but it just seems odd to me.
54 jurisdictions do it. Does
They
it
do
give
something.
our practitioners a competitive disadvantage?
I don't know. I mean, maybe. I think that's
think it
open for
could.
debate. It could. I think that's right, but I don't know. I mean, maybe it's something we need to poll the practitioners on to see what they think, because I agree it could. Maybe it's relevant to figure out what the society or the practitioners believe about this.
I just get back to the fundamental principle of we're telling these people, okay, come get yourself right with the board, but guess what? That's really not going to help you that much other than that you can still practice. This is going to follow you for the rest of your life. And I think that's a problem.
Doesn't it follow them for the rest of their lives regardless of
We
whether
don't
we
have to make
participate
it
or not?
just out there in the public for everyone to look at all the time. I mean, they can call and figure it out. I just think that's very punitive for us to allow someone to get right back with our profession, with this board, and then just say, but you've got this black mark for the rest of your life. I'm sorry, I believe in grace in some regards, and to me, this is a very ungraceful practice to participate in. Because you're telling people, you're never going to get this, you're never going to get beyond this. And is that a hindrance for someone wanting to get right with the profession going forward? I don't know. I don't know. I have a fundamental problem with this. If somebody wants to call and check on this person, I mean, I'll be honest. If somebody's done something very egregious, their license will be in revoked status forever. Forever. I mean, we've had people, I mean, we assessed one of the largest penalties when I first came on the board. It was over $100,000. And revoked this guy's license. I can assure you he's never going to get reinstated. He stole money from somebody. And so that license is in revoked status, and it will never leave revoked status. So what you're really talking about are some of these in-between infractions, because the most egregious ones will never get back into active status. That's my point. And so now you're really talking about this midsection of violations down here. And so I don't know. I mean, y'all tell me. I think the worst ones we're never going to reactivate.
I just don't think there's a big deal with requiring somebody to go to the board to figure it out. The other issue is that for these mid-level infractions, are we going to start creating an issue where, you know, we look like a regulator that's strong-arming people into to settling and paying these fines so they don't come to a hearing and have a formal action that then gets reported somehow? Maybe it does, maybe it doesn't. Does it put a chilling effect on people actually providing, maybe there's an issue here, maybe there's not, let's just go ahead and err and let the board investigate it to see if there's not, or do people start saying, oh, let's not do it because we don't want to harm the person? I mean, there's all these unintended consequences that can happen from this that maybe I'm being Pollyanna about, but it seems like it's a big deal to me.
Yeah, the further
I just wanted to add one clarification when we're talking about hiring somebody that's in your state and looking them up. That's one of the reasons that the ALD and CPA Verify came to be, was to link records across state lines. So there can be an opportunity where you have someone who you've revoked and you're never going to reinstate. But if they have a license someplace else and then they go to practice, the person who's been revoked from Tennessee, I doubt is going to tell the person that they're trying to get to hire them that their license was revoked from Tennessee. So there'd be no way for them to ensure that they know that, have that knowledge, unless they went to all 55 board lookup tools or called all 55 boards. So that's the scenario that I think ALD and CPA Verify provide the best.
That's what we're currently doing, correct?
But
we're just not telling them what they did.
Right. But
so if you go onto that website and you type in somebody's name and they got a revoked license, they're going to know that.
Right, but if there's a other status that is something that you think should be disciplined, if whatever the board determines is the scale of other than just the revoked ones of people embezzling, that should be something that if they called the board they would hear about, they would get to see that record instead of saying they don't send any information.
So basically, then each board then is going to go back and decide whether or not that person is worthy to have their license in their state. I mean, it kind of. I mean, what's the point of a board? You know, are they going to rely? They're not trusting each board's decision on how they discipline that licensee. They're going to go back and get the facts and say, we don't agree with that. You know, I mean, I just...
Possibly not. I mean, I think the Tennessee Board...
It can only be used
would do
against the
same.
practitioner.
Right.
Period.
I mean, I just don't understand why they need to know what they did. The point is, it's revoked or it's not.
You've got a question, contact our
Call.
board.
Yeah, or even if you want them to know what they did, contact the board. Don't put it in a nameless, faceless data aggregator that doesn't have any minimum standard of consistency across states. That's the issue to me. I mean, the issue, I don't care if they know what you did. If you did it, you did it. I agree with Casey on that. But the point is, if you can't assure that a practitioner in California and a practitioner in Tennessee will be reported exactly the same on the different gradation, I don't see how it's a benefit to our practitioners.
Does the database disclose to the reader, to the user, that the states do report differently? Is there any place that each state can describe how they're reporting?
Well, with respect to statuses, because that's another place that we tried to get uniformity and no one would have anything to do with that. So there are, I think, like 305 different definitions. So each state has a pop-up box that shows the definition for each status, so that active means something in one state, active may mean something in another, and so there are all those definitions. With respect to disciplinary data, it either says the board participates and there's no information on this, which means that you're clean, or it just shows clean. The board doesn't send this information or contact the board. It does not go through what are the different kind of violations that they send.
You know, I would just like to interject here, because what pops up in my mind the most is protecting the public. And to me, I believe in grace. I'll say that for sure. But someone being held accountable for what they did they made that decision when they had the wrongdoing and they were disciplined for it, whether they were activated again or not. As a person that might want to hire one of these people, if I see there's, I would like to know if there's been discipline on anybody that I'm looking up. I think that protects the public. Now, then you can go that extra step if there's not enough information there. But if I look up and someone has, committed fraud, and I'm trying to figure out which CPA I'm going to hire, and there's one that has a red flag or whatever, and they've committed fraud, well, I'm going to drop them from my list. And I know that sounds pretty bad, but they made the decision to do the wrong thing. And I don't care when it was.
That's the point. It doesn't tell you that they committed fraud. It just has a flag.
No, that's what I'm saying, though. It's got a flag, so you contact and you find out what it is. And, I mean, either way, they're going to be marked off my list. Whether there's if it says contact the board.
I agree with you. I would do exactly the same thing. I just don't know what the value is in having the middleman. I mean, if you adopt the policy of doing that with everybody, no matter what, then what's the value of the data?
I guess I'm just
There's also the case.
I don't have the time to do that.
There's also the case where we have habitual offenders, as for lack of a better term. There may be minor offenses, but we've had cases where we've had habitual offenders, and we reinstate them. But if you're looking at their history, you might want to know that they've done that several times, even if it's minor, because you might want to wonder, are they going to do that again?
And we do that here.
Yeah.
We did that here yesterday.
Yeah. I think a person's history, is, especially if it's habitual and repetitive, is good for the consumer, for the public. I mean,
if I were a practitioner, my concern would be that I may not get somebody as conscientious as Judy, and so when my name comes up and there's a flag, instead of calling the board, they just go to the next name. And if I was committed fraud, you need to know that, but you may never figure it out. And you may figure out that I was 2 days late with CPE, or I missed an hour. I thought an hour counted for state-specific ethics, and it didn't, so I had to do 5 extra hours. But there's a flag there, so I just go to somebody else.
Well, and I think that this board determines the data that gets sent. So I think that we would determine. Yeah, I mean,
the point is, there's a flag. If there's a flag there, it doesn't matter what it is.
No, I mean, we can determine if there's a flag. we can determine if there's a flag or not a flag. If it's administrative and something like that that's so minor, I would recommend that this board decide that we have a certain, I mean, I would think it'd be pretty easy to put together, like the degree of their action, what it was that they did. If somebody had fraud, I would say they get a flag. Okay, if someone missed their CPE course because they took the wrong course or something, I don't think that's administrative, and I don't think that would be a flag.
I agree. I think the ends of the spectrum would be very easy to
Yeah.
It's all the stuff in the middle that's not. And so
Okay.
what happens if you didn't enroll in peer review, and then you were notified about it, and then you re-enrolled immediately, and then 3 years later comes around
And
and
those-
you come find out you didn't do it again, and you re-enroll. We've seen that before. Like, is that something that rises to? I mean, these are intense level decisions that I don't frankly think.
And I think it would only, I would hope that this board would decide that it would only be serious offenses that would have flags.
Again, serious offenses is going to be in revoked status. That's what I get back to. If a license is revoked, that ought to tell you enough right there. And you can call the board and figure it out. If something is serious and egregious, it is incumbent upon our board not to reissue that license back to that individual. Otherwise, we've made a grave, grave mistake here.
I think I heard we can decide as much or as little information as we want to provide. I mean, the way that I guess the participation is being determined here is left up to the 55 jurisdictions. I'm still concerned about forfeiting mobility rights for our people. And if we can design the bar so low that we can at least minimally comply with the participation requirements of the program without giving away our principles, I would advocate that we do it.
Basically, we've got to give the detail of what they've done.
We get to
No.
decide whether we do or not.
So what I don't understand is we're already providing the information as far as active, non-active, that sort of thing. Is that not enough?
No.
What else do we need? I mean,
A
that's...
flag on discipline, that they've been disciplined per the parameters of your individual state.
Is California
laws.
threatening us to end mobility with Tennessee?
Excuse me?
Is California going to end mobility with Tennessee if we don't do this?
Yeah, it does not meet their statutory requirement, and yes,
And we're in the process of finding the states that don't provide mobility with us, and we're going to do reciprocal actions, right? Haven't we decided as a board to go back and...
You all had voted to pursue that. I believe TSCPA is not able to do that this session, but would consider it in the future.
Okay.
Could we be as minimal as only flagging those that have been revoked or suspended?
The thing is, I can't make that determination because I don't sit in and see what your discipline is. If that's where the boards come out, where your discipline, that's the range, like the really egregious ones. What the California statute says that it has to have a publicly available information regarding discipline that was equivalent to what was required for a practitioner to fill out in the form under practice privileges, which is what they'll go back to. It'll basically, no notice, no fee goes away, but what will be instituted instead is filling out for the practitioner to fill out the form and then self-disclose. And it's really those practice violations. I can get you the specific language, and then maybe you can match that against what in Tennessee gets revoked or suspended, whatever your statuses are. But I can't make the determination without having all the information of what would go into a determination to revoke or suspend someone's license.
One thing I would like to also say is we could have used that information even yesterday or today, and that would have been very helpful for us to know. We don't know about, like, we were inquiring about a Kentucky.
What do we not know about?
The Kentucky. We don't know if that revoked status is related to the Tennessee revoked status or if it's a totally different thing.
Even if we go down this road, you're not going to know that without calling the board.
Okay.
So, and I inquired with the board, but they just haven't been able to get back to me yet.
Okay.
For the record, once they get a flag, it's permanent.
No, it's up to you.
It is, because they back this database up. It's out there.
Well, I guess it's permanent if it's already been publicly disseminated in your newsletter, and your newsletters are digital and online, it's going to be permanently there anyway. But with respect to the flag in the
Just talking about this database.
if you change that flag, like the person that if you reinstated somebody today, and it changed in your database to reinstate it, and you remove the discipline flag, then tomorrow on CPA Verify would happen.
Maybe I'm just not bright, but
Part of the problem with our database is when a license status changes, yes, that would get updated, but when someone's been disciplined with this board, they are flagged, and it doesn't go away after a certain period of time. So we're talking about an active licensee that is disciplined for failure to respond to a CPE audit, and they're flagged with the modifier in our system. We don't have a certain period of time that we remove that flag because the status of their license was never affected. And so I'm having trouble envisioning how and when you would remove such a flag, because we don't do that. If anytime somebody from the public calls us, we would provide that information, whether it happened last month or whether it happened 4 years ago.
Right, and really that's all CPA Verify is, a database that is going to provide the same information that you are allowed to and are currently giving on your practitioners now. And that's why it says contact. That's why the ALD committee came to the conclusion that contacting the board made the most sense, because that's what people were doing in the past. It's just that they would have to check 55 different online databases and know where to look. And the CPA Verify allows records to link across state lines and give the public an opportunity to see the history and then make the call and provide the same level of information that they would get right now.
What's NASBA's view on firm mobility?
Our view is that it's in the UAA, and it's really up to the boards. If the boards determine that they want firm mobility, our recommendation is to use the language that's in the UAA so it'd be consistent.
Do you think firm mobility is either a good thing or essential in the future?
I mean, we don't have an opinion on that. For me, I think if there's going to be firm mobility, then firm data needs to be in the ALD as well, and link those records across the state line so that the public can see where firms are.
I guess it just strikes me that I'm not NASBA, thankfully. I'm sure the profession appreciates the fact that I'm not NASBA. But if your job is to advocate on behalf of best practices, et cetera, among the different state boards, and you hear that a bunch of state boards are very concerned about one state strong-arming their state and their practitioners into participating in this thing, maybe we go back and actually advocate against people passing statutes in their states that require this type of thing, that if you don't comply with our rule, then you're out, and we're not going to have firm mobility with you.
The thing is, there's 54 jurisdictions have been fine with providing the disciplinary flag, so it would only be Tennessee that would be asking NASBA to
just to make sure I understand this, 54 states have had a discussion about the fact that because of there's inconsistency in the data reported in this flag, they're okay with the fact that could be used as a blacklist against their practitioners. They've had that conversation, and they've said that they're okay with that.
I have not attended the board meetings to know that. That's not what I've done. They've agreed. They've talked at their boards, and they send the data. So all of them are sending the data. At this point, the two that aren't are in the middle of going from an old database system to a new database system. So we're waiting for them to get to the new database system to build the feed from the new database system.
So do we know what type of data is being submitted by their boards and the different gradations?
You can look into if you log into the ALD and Don has the login credentials, you can see what the other boards are sending.
So it could be fair to say that in fact other boards don't agree with that position. It's just that maybe all they're doing is submitting flags for people who've either been revoked or suspended in their license. That doesn't mean necessarily that they're okay with the fact that they're being strong-armed by another state's General Assembly.
I have not had one state at least tell me that they feel strong-armed at all.
I mean, I guess if you did the minimum necessary, I guess we wouldn't feel strong-armed either, I guess. Maybe the point
and most of the boards were sending their data well before the California initiative started.
On a positive note, I mean, I think we've been focusing on the folks who have a history of violations, but for the people who have no history of violations, this would be a positive thing because you can go to one source and see that there is no problem, and the public can find that person has no history. Now, for those people, it's a good thing because it's a one place to shop for finding that out. So, I agree with Casey. I think it's important to know a person's history, even if it's been in their past, if you're getting ready to hire them for something that's very important to you or vital to your organization. So
they can already look that up for Tennessee anyway?
They can call.
So if they can already look it up, what's our problem? I mean,
How many people on this board called the state board here before they hired their last employee?
Say what?
How many people on this board called the State Board of Accountancy for Tennessee when they hired their last CPA employee? I mean, if it's so important, we need this, why haven't we been at least
I think
making the
another
effort
way
as
of
well?
kind of phrasing that question is,
I mean, it's the
that
same
we've
effort.
been talking about this as if this is the only way to get information about prospective employees or active or inactive CPAs. I mean, the fact is, many people, our firm would basically do a full background check on a prospective employee. Others might not, but our firm generally does. And, you know, everybody can Google somebody and get some information if there's been a, actual court case, presumably, that involves the person. So we may be overblowing the significance of this one way or the other to our practitioners. My concern is we would be the outlier if we refuse to minimally participate under the standards that we decide in terms of what we're going to disclose. And I don't think unraveling mobility is good for any of the practitioners in Tennessee or anywhere else. And I don't think it's perfect. And I agree the information is not consistent and maybe not even particularly useful. But I also don't want to see mobility torn away, because I think we worked long and hard to get there.
Yeah, but I just think that if you're looking at, let's just say that this becomes your firm's...
They don't have firm mobility, by the way, California.
Firm mobility, yeah,
Right.
I was
They have
referring to
individual.
individual
Right.
mobility.
But let's just assume this is your firm's chosen means of doing some background checks on a candidate's license. You got two candidates that you're looking at hiring. One's got a flag from something they did in the past. They may maybe still be active, and one doesn't. Who are you going to pick? I don't care what you say. They're going to say it ain't worth. That person is going to get disqualified on the front end, and you're going to switch over and you're going to give preference to the person that has no history, just because it's going to take more time and there's question. It creates a question. At least it wouldn't in my mind. I would say, nah, I just don't want to mess with it.
I don't see what's wrong with that.
I don't either.
I really don't.
So if you're criminally or if you're charged for something, I'm just talking about in the law, there's no reason for someone's record to be expunged. I mean, what's the point? What's the point of having that? I mean, it's you make a mistake in the past and you're screwed for the rest of your life.
You made a bad decision, somebody else didn't.
But it's up to that employer to go how far they want to go to look into what the problem was. And
my license is in good status today.
Yeah, but I don't see. I'm not sure what I understand what we're afraid of here. I mean, I don't understand what are we trying to protect offenders, or are we trying to protect the public from the offenders? So
My point is we wouldn't give them a license if we weren't protecting the public. Right? I mean, why would we give them a license if we're so concerned about someone behaving inappropriately with the public?
why do we have the information still on our database if we don't want anybody to know about it?
Well, it's there. We just don't broadcast it everywhere.
And why do we consider it when we
Why
make
is it bad
decisions?
on their database, but it's okay on our database?
Because it's just going to be used now as a tool. It'll just make it that much easier to knock people out.
I don't see anything wrong with people using it. I really
Can
don't.
outsiders view our current database and see the flags, or is it just that they call the board, you say, when you answer, do you say there's a flag and then let them ask for more, or do you say, here's what happened? How does that work?
There's actually two mechanisms for the public to access that information. One is entirely electronic and the other is contacting us. Currently, the electronic version of how we report our discipline is, well, first you have verify.tn.gov so you can check license status, but we also publish our monthly disciplinary action report. So once a month, any disciplinary, formal disciplinary action, so any consent order, agreed order, final order from this board, the amount paid and a brief summary of what that allegation is published to the website once a month. Currently, that information is it's sorted by board and it's sorted by month of discipline assessed. There is movement for that to become a searchable database in the future, because right now, honestly, it's hard for a consumer to find somebody unless you knew what month they were disciplined in. Or you can contact the board and request that information either through an open records request, or if it's an easy answer, staff obviously can answer that question. So those are the two mechanisms. Anybody outside of Tennessee or inside can look at the website and access that information. The open records request, we could deny if it's not a Tennessee citizen, but so they can access that information through the website currently. It's just not very searchable.
So it's already there. I mean, I think
This
the
is
public
what's already
is
there actually is what happened. what would happen in this one is a flag, no matter what it is, which then leads people to wrong conclusions. That's the
We
difference.
decide if there's a flag
I
or not a
understand,
flag.
but what I'm saying is at the end of the day, we only decide if there's a flag, if does a flag exist or not, but there could be 15 reasons why we think it's worth saying that a flag exists. The point is, if you come to the board, you see that a flag exists and immediately know what exactly it is. So you actually have better information.
I can tell you, I've looked up things on the database, but I've never taken the time to call. And I just feel like I don't feel like that's moving forward. I mean, we record these things. I just feel like transparency and is best.
I'm all for transparency too. The problem is I want transparency with data that has integrity. And this data is the definition of lacking integrity. Because if you have data, you can make decisions. The decisions won't be good unless the data is right. The data will not be right. There's no way for it to be right here, absent NASBA doing something.
I don't know that.
I disagree.
I don't know that our data being absent entirely from this database is less transparent than, less or more transparent than having a flag there that alerts somebody to. I mean, we can't control how they perceive that flag. That's not our responsibility. The flag there lets them decide whether they want to go further or not, but not being there at all seems to me to not be a good thing.
This is a step in the right direction, but I think NASBA has a lot of work to do. I mean, right now I'm thinking its benefits outweigh its costs, but its costs are many. And I guess, I mean, early you said, oh, well, we're not worried about those minor infringements, but in fact, they're there. And so it just sort of sounded like maybe NASBA hadn't thought this through thoroughly as far as the repercussions, and I guess that's just a note. You know, I hope that NASBA, it sounds like you will continue to work on that.
With respect to the ones that don't need to be sent, that's by the statute in California. That's what I was referring to. We've always left it up to the boards, to their discretion of what they want to send. It's their tool. With respect to the California initiative and meeting that standard, the CPE complaints and actions and failure to renew, those are not the type of disciplinary items that they need flagged.
We've probably hashed this to where we can make corned beef out of it, but on ALD website and CPA Verify, they note that it's up to each board and that they're not responsible. They take no reliability in what's on here. It's fed to them by the boards, and to contact the board if you've got questions. I would entertain a motion to get this moved forward to either approve or not approve, but put some guidelines, or to refer it to staff to come back with the guidelines at next meeting on what we would flag if we decide to go that route.
I would move that we would move forward with participation in the program, but direct staff to make recommendations to us as to what level of violation would be deemed to be a flag that we would submit if we did participate in the program for our future consideration.
Second motion.
Oh, okay.
We have a motion and a second, and realizing that as part of that in the discussion here, that's going to require some time and update in IT moving forward.
I would be happy to work with the staff to help with any of that. If there's, I don't know if you need, if you want board input.
We have some input from the Tennessee Society. Yes, sir.
I just want to go on record as saying that the TSCPA supports individual mobility, and that's a high priority. If NASBA's going to be sanctioning states and declaring them substantially equivalent and allowing California to adopt their licensees for mobility purposes, I think it's important for us to participate at some level, even if it's just to flag those violations that have been revoked or suspended. And not try to get too deep into that, but mobility is important, and I think for this to stand in the way would be bad for everyone, really.
I agree with that.
We have a motion and a second on the floor. Can we get, yes, ma'am?
May I ask a question of Maria?
Sure.
Does this motion that's on the floor, does that provide us enough information that you can help me with recommendations, or do we need more guidance?
I think what I would recommend is that I can send you, if you don't have it at the ready, the specific nature of what the bar is that you need to pass to meet the California statutory language, and that would be what the board, the recommendation.
That would help me be able to make a
recommendation.
recommendation.
To make a
Okay.
recommendation should be based on that from what I've heard here is what I would.
And if that bar is higher than we're comfortable with, then so be it. We can reverse, assuming this passes, anything at the next meeting.
So, Mr. Chairman, what exactly are we voting on? I mean, we're not
voting on proceeding with establishing the guideline based on this
We need to vote
motion.
on that? If staff's just coming back with a
No,
recommendation?
we are voting on, since we've had such a detailed discussion, based on the motion that's on the floor, that we want to move forward at a minimal level with a flag that satisfies whatever's needed, assuming it's within the guidelines.
We're not going to move forward until we get recommendations from our staff about what that minimum level
That's
is,
correct.
and we're comfortable with it. And
That's correct.
then we'll vote again to actually participate. Is that right?
That's right.
I mean, in a situation like that, I don't want to risk firm mobility either, and I'd be willing to vote for that. But I want to make sure that if I vote yes for this, I'm not voting to say, yep, despite the concerns, we're going to join.
We haven't determined yet, and his motion was that it would come back with their guideline.
I just want to add one thing as far as timing. So the California statute, all these hurdles need to be met by June of 2017, because that's when they make the determination and immediately begin rulemaking to transition states that don't meet the hurdle back to practice privilege. So time is of the essence just in order to be able to meet that hurdle in June.
We have another meeting, but I don't think anybody's really concerned about what California thinks.
But my question,
Well,
too,
except
is...
if you said about the individual
I
mobility,
understand.
it would have
We
an
want to
impact. I
protect
wanted
our
to make
members.
sure you understood that. Okay.
But I appreciate that, though.
Even if we, I mean, my question would be, knowing at least how things work in Tennessee, if we told you today we're wholesale joining, I don't think there's any way. I mean, maybe we could even be compliant by June of 2017 if we did it today, right? I mean, there's IT issues that need to be resolved, and IT systems build-outs are extraordinarily complicated, even if they're really easy. You think they're easy concepts?
Well, there's two ways that states are addressing it. Some are that have the ability with their database to send the data directly, change their ALD feed to send the data over. Others that don't are filling out a template, basically an Excel spreadsheet, that they send to NASBA that get on a secure FTP site where they drop off their other files, and that gets uploaded into the system separately. So it really wouldn't, in that scenario, involve IT resources as much as staff. And like I said, NASBA is prepared to help fund that effort to get the Excel spreadsheets.
Right, but I guess my question is, how many licensees do we have? 7,000 or so? 10,000?
Wendy has...
How do we figure out, of all the entire group and what their complaint history is? I don't think we have enough time in 6 months to compile
You've got a
that.
different database that we use on complaints, is that correct? And internally? The one we were in yesterday.
Different from, right, that's our licensing database, yes.
So you pulled up disciplinary actions on the one I mentioned earlier this morning, that we actually disciplined, but he didn't have a Tennessee license. He was practicing in Tennessee.
Right. But we would not be able to feed that type of...
I understand.
Okay,
But what, to answer Gabe's question, you're already going to have, I hope, you can sort by disciplinary action with that database.
I'm not sure.
Okay.
I'm not positive. We clearly can sort by who's been disciplined and who hasn't, but from a historical perspective, I'm just not clear on whether we notify it or we are able to aggregate it based on type of discipline. You see what I'm saying? So everyone has a modifier who's been disciplined, but if you were disciplined for a CPE audit versus discreditable act, I'm not sure I can separate those historically.
Okay.
And I would just offer that something we've done with another state is to take advantage of the fact that the records are publicly available, the orders are on record, and look at all those and have NASBA help parse those out basically into the format of that Excel spreadsheet based on the criteria that, or orders in this magnitude would be included and ones that are CP violations would not. So there's data that's there that's publicly available that we could use as well, if that would help.
This vote is only to proceed with that until we get the guideline, and we'll find out by the next meeting whether we can even feasibly do it without.
When you say proceed with that, what is that?
Proceed with the fact that we want, that the board approves, assuming it passes, that the board approves of joining it.
Mobility.
Well, no, put in the flag out there, but we have to define the flag, and if we can get the information to make that flag.
Really, I think it's participation in this data feed program in order to preserve mobility, but really the motion is relative to participation at a minimal level in this ALD data feed program.
Subject to
Subject
creating
to
the criteria.
Staff's
Yeah, the
We just need to move it along one way or the other.
Mm-hmm.
Okay, I'd like to, I think, have a roll call vote on that one, just for the,
Pamela Church.
Aye.
Gabe Roberts.
Aye.
Trey Watkins.
Nay.
Stephen Eldridge. Casey Stewart.
Aye.
Don Royston.
aye.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
The ayes have, the motion carries.
Thank you, Maria, for helping answer some questions. Appreciate it.
We also appreciate the trip from South Carolina. Old business, state-specific ethics course. Would you like to bring us up to date on your correspondence back and remind us that we voted to have them expire, et cetera?
Yes. All right, so on your iPads, this is titled State-Specific Ethics Comments. And as a reminder, we've been discussing this for a while, but at the last meeting, after a fairly lengthy discussion, the decision was, due to several conversations over the past 2 years of inconsistency and some concerns over the quality of state-specific ethics courses that this board has approved, the board decided to expire all of the currently approved providers on 12/31/17. I was also instructed to send a letter to those sponsors, letting them know that the board was considering an alternate direction with regards to the approval of state-specific ethics sponsors. And also to invite comment on their thoughts pertaining to our framework and anything that they've would have concerns about if we change directions and potentially approving maybe one sponsor or one provider of content. So in your documents, you will see the letter that I sent, and then you will also see 2 comment letters that I received by the deadline of 12/31/16. I also passed out to all of you an additional comment that I received yesterday from PES, I believe. I believe the comments in the email I received yesterday, they are indicating that they were commenting on the Virginia's model. And I will stop for a minute. I did have a fairly lengthy conversation with the director in Virginia. So if you are okay, I will try to explain to you their model, or would you rather me wait? And if you have questions about that later, would you like me to go through how Virginia they've gone to a single provider. I can outline how they operate. So they went through an RFP process. I understand that they had 2 folks submit a request to be the vendor of choice for the state-specific ethics program. They chose the society in Virginia to be the provider of that content, the developer of that content. They also created a committee. It's an ethics committee. It does not include any board members, and it does not include any members from the society board. It has some professors on it, some various folks that are familiar with educational products. So this committee has a minimum of 3 folks. That committee creates an outline of what that course would look like. I believe that outline is due or is approved by the board typically in October of each year. And once that outline is approved, that outline is provided to the society, and they have 3 months to create a program. That program is then submitted to the executive director, and the director has the authority to approve the program without additional board review. Then the society has until February 1st to deliver that particular product. So there's a pretty substantial agreement between the 2 and dates, etc., on how this works. Then if you would like to provide that course, let's say you're a professor and you want to provide that course, then you would apply to the board to be a speaker, basically, or to provide that course. And you do that via a 1-page application in which you attest that you have an active license, because that is a requirement in the state of Virginia. And you also assert that you will obtain the documents, the course documents from the society. And then the board approves you as an approved presenter of those documents. And you go obtain them from the society, present the course. Not sure how often you have to reapply for that. But that's in essence how it works in Virginia. And you will see in one or all, maybe 2 of the 3 letters, a reference to Virginia's model. That's why I thought it was important to kind of cover what they have done. They're the only state that I'm aware of that has gone to this model. Keep in mind, not all states have a state-specific ethics requirement. Some don't have an ethics requirement at all. So we're talking about a smaller subset than the full country that have this requirement. So you will see in your comments obviously some concern from these providers. We received one from Perry Moore, who's a professor at Lipscomb, and he regularly teaches this course through the society or on his own, and has been approved by this board. I think he feels there would be a significant impact to his ability to do that, obviously, and he's not in support of it. You also have a comment letter from a CPE, creator of materials, author of materials, that then they resell that to CPE providers, Delta CPE. And then the one I got yesterday was from PES. They are an approved provider through NASPA, and also a current provider of our state-specific ethics. So their comments are associated with the fact they work well with Virginia, but they indicate they've heard many concerns from licensees regarding which I thought was a little different, about the Virginia model. So I know there was some discussion at the last meeting about potentially moving towards, one vendor and one place to get this in order to help ensure a more consistent, accurate program. So where we are today is, how do we want to move forward? Every course that we have expires 12/31/17. Do we want to move down the road of potentially one vendor? Do we want to move down the road of more oversight with the current vendors? Or have them all, anybody who wants to reapply and then institute a yearly or biannual oversight process that's more comprehensive than what has been done prior.
What is the status of the Tennessee Societies program? Do we, we've had kind of a little.
I believe they're close to
preview.
launching that. If
Okay.
they would, do either one of you want to speak on that?
As you all know, we sent that out to you prior to the last board meeting and got feedback from many of you and have incorporated that into the course. Some of the feedback from you all as well as from other members that we've had review it was the need for more case studies. There seemed to be a desire that was one of the very beneficial to have those, and so we're working on creating those case studies. After that, our plan is to get that out to some other constituents for additional review, just to make sure that we've got it where we want it to be, and then to roll it out. But yes, we are very close.
What about the gentleman's comments about being NASBA compliant? I mean, I don't know if you saw the letters.
Brad may be able to speak better to that than I.
Quality assurance process they go through with on-site.
Right.
I'm not that familiar with it. Wendy, help me here
Well,
if you are.
unfortunately, I'm not super,
Yeah.
I just know he brought up some comments. I just want to make sure, are we going to address those, or
we
are
don't
y'all?
submit for that approval because we're not subjected to that. We have an automatic approval, but I'm confident that that online program meets or exceeds all of their standards. I've
Okay.
seen what's being offered, and that's my opinion. Wendy,
I'm
correct
just
me
not
if I'm wrong.
familiar enough with the self-study
Right.
standards to know for sure.
I couldn't tell you one way or another. I just know he thought it was an issue.
When you first created the program, that the society seeked approval through Mark to provide the course that they are providing. So
Our goal was to collaborate with the board through Wendy and the staff and concentrate on those areas that are, well, number one, correct and accurate, but two, most needed and identified by the board. And we feel like we've created a product, but that's not to say that a lot of other people can't create the same product. I think that QAS approval that was referenced by Professor Moore may be a stretch and an attempt to discredit the energy that I think we've all identified in creating something that's consistent and accurate and targeted toward the need of what the board feels like is important. There are lots of different providers out there, as we've identified, that are moving in lots of different directions. There are a number of ways that this could be addressed, but that QAS isn't something that we submit for.
Brad, is there any problem with talking with NASBA so that we can say that they've blessed it that it does, whether you're an approved provider? Because we're up against.
Yeah, that's like that CPE registry. I think it's of the same vein, is it not, Wendy? The registry and it's substantially the same thing. And
I'm not asking that you get that or questioning that you get that stamp of approval. I'm just saying run the concerns of this by someone at NASBA that sets the standards to be sure we are, because y'all got a quality product right now. And if it's a simple thing that you have to have more, I sat through 2 CPE things the other day, and all they were sales tools that the county today offered.
To work with NASBA to the extent that Wendy feels like they'll be supportive or accepting of a review to the
What did we vote for on that? Did we vote to, I know we expired them all, did we vote to annually approve those, or how did we deal with that going forward? Did we? Okay, that's what we need. I think if you put in an annual renewal, I wonder how many of these 20-plus vendors will just go away, because they're not going to want to fool with it, probably.
We only got 3 comments. I feel that some of them are not providing it any longer. Because outside of these comment letters, I didn't even receive a response from the others.
I know y'all are going to put out a quality product. I get a little uneasy when we give sole authority over CPE to one group. I don't know. It just doesn't seem like it's competitive. But I do think if it's easier to use, it's a good price. I think you're going to end up with the majority of the people using it anyway.
They're clearly good products. They're accurate products out there, and they're quality products, and they're clearly inaccurate, misleading, and totally useless requirements of specific information. It's not like we're trying to create a leadership topic or some soft skill topic. this is a state-specific laws, rules, and ethical implications. We've incorporated some case studies that are unique to Tennessee, and that's just an example of probably what some other vendors are doing. Our concern was that there's so many vendors, and some are misleading, and some are totally inaccurate based on the reviews.
Which gets to the point, I think, if we can approve them on an annual basis,
exactly,
the content, then at least that control's brought back in. And I think what you're going to find out is you're going to have 3 or 4 people provide this to our practitioners.
I think pretty much the conclusion we came to was to minimize this board and the staff's review time, because having to make sure even if it's only 3 or 4 agencies that are putting on these CPE courses, it's just the state ethics one. It's not for all CPE credits. It's just the state. And if we just had one partner, or that we could possibly just make sure that they're staying on top of it, which would be the Tennessee Society. I mean, that's an important course. That's what we came to the conclusion of. And we just didn't want just anybody.
Our goal was to run the cost down to some break-even level and make sure that it was reviewed on a regular basis by the state board staff to ensure that it was accurate. But it also needs to be compelling and interesting, and not something that's repetitive for your employees that are concerned about reviewing the same video every year or the same misinformation every year that may or may not be helpful to them. Our intention is to invest enough in the product and utilize the softwares, and ideally most of it would be presented online. We're talking about a 2-hour on-demand ethics course that you could take at 2 o'clock in the morning or 2 o'clock in the afternoon or whenever. But there may be some value, I know Gay mentioned this, in her staff getting together and interacting during a live presentation, and for that live presentation of some specific course material, not just a rough outline, maybe have some presenters that are trained to go into firms in larger groups, so that group interaction, there may be some dynamics that you see value there, and it's easier to present. But our goal was to get something accurate, high quality, interactive, case study based, and do it online so that it can be easily obtained at a very low cost. Currently we produce our product at about, I think it's $55 per view, and it's a 2-hour course. We were thinking this could be run down to about half of that cost if the volume came up, and I think the production costs and the time it takes to maintain those records and all that should pay for the cost to put it on. But I can understand that.
I kind of like the idea of us providing an outline of what content should be there, because I feel like if we're going to require the state-specific ethics to our professionals, it should be incumbent upon us to give the details of what we want them to learn about Tennessee that's specific.
You have a rough outline.
We do have a rough outline.
There is an outline.
Okay.
It most likely needs to be reviewed and updated.
Right.
And to me, that should be the basis for everybody's course content, period. I mean, it shouldn't waver from that. So to the point of review, it shouldn't take too long to review if the topics are being covered.
Particularly if we reviewed, say, on a biannual basis rather than annually. And I'm a little bit reluctant to prohibit live presentations of this training, or frankly any other training. And so I would like to see an option that would permit, real live facilitator-led training in addition to a self-study component. I have no objection to that. I'm a little leery about sole sourcing the content.
I just want, for clarity, you mentioned it, and Kevin just mentioned it too. Is there an option now, or would there be an option for the live presentation, like if Dr. Moore wanted to go and present the CP to whatever groups he's been going to, that he could go and do that?
We can create that based on what we've created with our online product, and we will likely do that if the board maintains that as an option, because I suspect that some of our large chapter meetings, for instance, yesterday I was in Chattanooga, we had nearly 300 people in attendance, and they love to do the 2-hour update at a luncheon, for instance, and it knocks it out for a lot of people, and there's some value there. They can interact and discuss at their roundtable. So we see value there. Accuracy and compelling information consistently applied without being inconsistent or downright inaccurate or old is our biggest concern. And with 20-some-odd providers with no follow-up, some of which were provided or approved 10 years ago or 15 years ago, it just didn't seem to be. There's a better way to do it, and we're open to whatever the board makes a decision. But we have progressed to about 90% completion on our, more than that, maybe 98%. We're almost there. We were ready to flip the switch on January 1. We've got a little more editing to do, and within the next 30 days, ours should be up and ready and running regardless of what this board decides. Ours will be an option. So I just think for the board to make sure the licensees are getting accurate information, some standard needs to be applied to make sure that it is reasonably accurate and compelling. And
we can have a database that flags bad CPE providers, so we'll be able to know what we have.
There's a significant advantage to the TSCPA's familiarity with the rulings of the board and the procedures. When I first heard this, I was hesitant because we're taking people out of the provider status. But then, since I've been on the board, I've seen that there's some intricacies that I'm not sure jump out at you just from reading the rules. But maybe that's going too far. Maybe that doesn't come out in any course. Is that?
I think there's some advantages to being having a clear and concise understanding of where the issues are, and I know we tend to interact with the board staff and the board more frequently than some of the other providers, but I think any provider should stay on top of that and especially engage with the staff to make sure that the majority of the problems can be addressed in such a 2-hour presentation and not some of the technicalities of the rules and the law that are less of issues to the licensees. Yeah, I think there's value there, absolutely. That's why we've been working closely with Wendy and the State Board staff to make sure that we put together a product that licensees are going to benefit from, and the board and the public as well. So,
what's your impression as far as other providers? Do they interact with you to make similar assessments?
But again,
No.
if we're approving the content, it really shouldn't matter, right? I mean, at the end of the day, if they're either teaching what we want them to teach or they're not, and we either approve the course or we don't approve the course.
We don't approve the course. We've been approving the providers. And Wendy, upon questioning, when you looked at the one that you went through and spent, I don't know how long you had to go through and actually correct the deficiencies in theirs. There was pretty serious deficiencies, as I remember, and that was a major provider.
That's my point. I think we need to go to a more frequent, that these things sunset. They die at a certain period of time. If it's 1 year or 2 years, like you said, 2 years, which I have no preference either way. But, I mean, if they have to come back and reapprove, it's not Wendy's job to correct their material. Let's just say it doesn't meet our standards. Send it back. I mean, you don't need to do their job for them. We're not approving this course, period. If it's not teaching what we want it to teach, then I think we have the authority to not approve it as an approved course for Tennessee ethics.
But it is time-consuming if they submit it multiple times.
We also require Tennessee ethics, so I think that's part of this job of this board is we've taken that responsibility.
I know. I'm just saying I see as and I have thoughts both ways, but I see as one advantage that this would save resources, save the board's resources. But you're saying that's
Function of this
positive,
board,
but perhaps we need an open market, and I understand that too.
Yeah. I have a feeling you're going to end up with very few providers once we move to this, if we do move to this type of review. That'd be my guess. I think people are, you're going to reject some because they're not going to be good materials. I think we can all agree this will be the gold standard, and I think most people will want to do that just because it's going to be the easiest, most cost-effective way to do it. But I don't want to give, is it Mr. Moore or anyone else, the appearance that we've taken away something from somebody who's done, from all accounts, a decent job doing what he's doing, right?
Full disclosure, I mean, I've sat through presentations by Don, and also our firm has utilized Perry on our client CPE day to present, to a room full of 300 or 400 people.
Right.
And certainly, I believe that he's done a great job with his materials, and he certainly has the Tennessee rule book in his hand. I mean, there's no question about it. So in his presentation, that's great. I haven't seen any of the other providers outside of those two providers. And so, I think whatever we would do, I prefer to keep it open and not sole source, and keep an option for a live classroom component or presentation. But I think, what we saw of the Tennessee Society's product was first rate. And I think if we can, without overburdening the staff, create maybe a biannual review of the content for those providers that want to be certified, that seems to me a reasonable way to go. I'd be willing to make that a motion if the chairman is willing to accept it. There.
I'll second that motion.
Get the motion in its...
Can you
Okay, would you repeat the motion in form if she's going to
I
get
don't know
that
if
now?
I would or not, or can.
Yeah, that's why.
I guess the motion would be to proceed and to direct staff to accept either a self-study component as proposed by the Tennessee Society or a live classroom option in terms of presenting the required ethics training, and to allow providers to submit materials for their review to make sure that it is in accordance with our standards, and that review would take place no less than biannually.
Have multiple, you can stagger them by year.
Yeah.
So you're only looking at a couple each year.
Evan, is your motion for multiple providers of both live and online products?
Yes, I think it would cover both. I mean, if someone really wanted to develop an online course, I think we should look at it or be willing to look at it.
We're going to have more online than we will live. I think that's how our providers line up right now.
Are we saying as part of this that we're having, I guess, consistent content for TSCPA or any other provider?
That's what we're saying, that every 2 years we'll review the materials for content.
I think.
But each entity is developing their own content?
I would say
They
the
want to,
consistency
yes.
is with our ethical requirements, or with our ethics requirements, not necessarily with each disparate provider's courses. I don't think they have to be the same.
Who's going to write these standards?
We already have the outline, which she
Seems
needs
like
to
that-
update.
Okay, so that's
but
not going to
the
change.
basis.
Just
Well, she may need to update
The
that.
outline needs to update, so I'd have to redo that and bring it back to you all in
But the current courses don't expire until the end of this year, right?
Correct.
And so they'll have to re-up at the end of this year, presumably.
For some reason, I thought that at our last board meeting, we pretty much came to the conclusion that we wanted to go to we wanted to go to the society and have them, so we only had them doing the materials. We didn't have a lot of administrative burden by looking at a whole bunch. I mean, could we?
I don't think we voted on that.
Could we maybe vote on having one provider that's online and one or two
We already
that's
have
live?
a motion on the floor, don't we?
We have a motion and a second on the floor.
Okay.
So we just need to vote no?
If we're in discussion, I've said this before, and I just can't get it out of my mind. I mean, this is the only course, I think, that the rules say have got to be state-specific. I mean, other CPE can cover a lot of subjects, a lot of different things. There be technical, non-technical, there are guidelines, but this is the only thing that has to be state-specific. And what I've seen from the review of these vendors is in every case we've done a review, there are errors that pop up. And I think it's a real burden on our staff. The more sources there are out there, I think that, if we've got and I think it takes time of this board. I mean, I don't know how many times we've discussed this, but it's taken a lot of time. And I just think we need to narrow the focus here and need to have one course and one vendor, and cost is a consideration. If we can go the route that the TSCPA, and I don't think as a board we have a better partner anywhere in terms of we lean on them when we have legislative issues. I mean, there are lots of things they do to support us. I mean, I don't think we have that kind of relationship with any other entity out there or person. But to get the volume of this thing up where you can drive the costs down to our participants, you're going to have to push this thing in the direction of one course. I mean, the more alternatives you got out there, the more, I guess, there's going to be less opportunity to get the volume we need to drive that cost.
I don't even know how many of those vendors you have on that list are even still in business. I mean, are all those people active?
I don't know because I didn't hear back from most of them. I don't know how many of these.
Do we track that? I mean, when people submit I guess nobody tells you what course they take. Do they? How do y'all track that?
They would, I guess, in the audit you would be checking, but we don't then track, okay, well, this guy took.
It would only be those that got audited.
Right. So
not the whole population.
Does legal counsel have any issue with us granting a monopoly for a provider?
This board currently, under its rules, has discretion to deem CPEs approved or disapproved. If this board went through a process, I believe, similar to Virginia, where there is a mechanism of removal, let me simplify it. I don't believe so. So long as it's clearly stated on the record the reason that's provided. But I would caution the board to perhaps make a mechanism where that can be reviewed or other people could apply, just because of the possibility.
There is some concern.
Again, we have the option to decline a course.
Correct. You have a broad discretion. So in reality, if
you ended up with one, you ended up with one.
That's correct. So you could do a review process, and if it ends up being that that's the only board, the only provider that meets your standards, then that could be the case. But I would make sure that there is a clear public record of that decision-making process. Additionally, just considering. Because the reality is you only can accept credits you want to accept. You're not putting anybody out of business. They can still offer CPE in other areas. You're really only looking at one type of CPE. So I think in the end, if that's how this board chooses to proceed, I don't believe, based on how we are looking at it now, that there would be a legal conflict at that point.
Can we not dictate that the outlines and information provided, and this is obviously subject to the Tennessee Society, that since they're in the best position to keep it updated, that criteria be used in any courses going forward? And I may not be willing to that.
I think that the best, if you wanted to do it that way, the best avenue would probably be to change the rule so that is directly acknowledged in the rule. I think for the board to declare a particular provider the best,
you're saying course content, not that they have to use it.
They could use that to evaluate the other courses.
Right, because your rule right now has factors of what you're going to look at to approve and disapprove a course, but one of those isn't the rules right now as read they're truly not aimed at content as far as what's spelled out here. Obviously, there is content that you can consider as far as, is it accomplishing certain goals, is it qualified by the AICPA, TSCPA, things like that. But I would be hesitant to, without a rulemaking process, to go forward to only.
Does this require a rulemaking process, what we're talking about with this motion?
That was actually what I was looking at while you were talking about, and it was something I would definitely want to run by Chief Counsel to be sure.
Okay.
The rule does have a very explicit distinguishment that this board has the absolute authority to deny and approve CPEs that are covered within this rule. I think that is a very broad rule that allows you to enact policy and how you would like to do that approval and denial
for cleanliness and for public disclosure, it might be worthwhile to eventually encompass that policy in a rule, but I don't believe it is required as it is written now.
We want to vote?
We have a motion on the floor and a second.
Can we repeat
hear the
that
motion?
motion?
It's long.
Well, I will tell you what I wrote down. I wrote down that the motion was to move forward with allowing folks to submit a request for a self-study or live course, allow the providers to submit materials. They would be reviewed, resubmitted no less than biennially, and that we need to revise the outline to provide to these folks.
What you said?
A little more eloquent.
I think that does what Casey said. It's at least we're narrowing down our focus a little bit instead of just waiting and tabling this issue. I mean, it's at least it's a step towards what we've discussed.
I think, at our last board, the letter that we sent out, maybe I'm just confused, but I felt that we were moving in the direction of partnering with them, with the TSCPA, to provide that. I mean, if you read the letter, it's pretty clear we were going down that road already. Now we're changing direction, right?
I think Trey is correct, meaning we didn't vote on it, but I do agree. I think the sentiment of a majority the last time seemed to be that they liked this idea.
Yes.
I think of it in the framework of, if we had the resources here, heck, we wouldn't be having this conversation. We'd create a course and people would come to us to get the course, right? We don't have that ability, and we aren't experts in that area. And so to create the best course we can, how do we do that without straying from that too far? Well, we contract with an outside group to help us do that the way we would like to see it. I
guess I
we
feel
did
like
not
we're
vote on it,
backstepping.
but that was the conversation. There were a number of folks in support of one vendor.
But in our letter dated November 28th to the providers or the sponsors, we created a clear impression that, okay, we're going to terminate the existing courses, but we did not spell
Imply
out in
that-
that correspondence that go away forever because
No.
We don't want you anymore.
And I don't think that was the vote either. I don't think a decision was made. The decision was, we've got to do something different.
We got to rein them in.
So therefore,
Because we're not
everyone's
good.
going to expire, and then we got to figure out, what are we going to do? Are we going to let them reapply, or are we going to go down the avenue of potentially one provider to help with the consistency?
Oh, we've got a motion and a second on the floor, but if we wanted to go the different direction and contract with the one provider, could we get a legal interpretation or a legal ruling on whether that would be getting us into trouble or not?
That's actually what I was going to suggest. It may be worthwhile for legal to produce a memo for you just to analyze any possibility of risk. Because even under the rule, under Section 3 of 002005.04, there is a list of other providers that not private companies that are deemed qualified. So I think we need to be specific going forward that we're not encompassing. In our rule, we have already deemed certain professional organizations, certain programs, college and universities, in-house and in-firm companies. Those are already deemed qualified in the rules to offer CPE requirements. But you do still have E of that list, programs of other organizations, accounting, industrial, professional, et cetera, recognized by the board. So I think in that category, you can absolutely exclude who you would like, but there are still A through D of organizations that are deemed qualified in the rule.
Gets me back to my point. It's like, why would you not just say that anybody can apply? We do not have to approve everyone that comes in the door, period. If she wants to approve one, she can approve one.
Seems like maybe doing this and seeing how it goes is not a bad approach. And if it's only a few and if they're easy to control, then maybe that's a good way to go forward. Do other states do this? Do other states have just the state society as providers?
Virginia is the only one that I'm aware of.
The only one.
One attempt potentially to bring some consistency to the message to the course is to allow us to produce the online version that would be available to anyone and create us and the board. I consider this a partnership with NASBA and AICPA and the state board as well. Create a product for live study that contains the information that we're looking for. And if you want to use it for your firm or a larger group at a chapter meeting or wherever, this is the course. It's not just an outline, it's the course. And we can qualify instructors to teach that, not necessarily ours, maybe someone in the firm to teach that course, as opposed to someone creating a different course using a rough outline that is going to require some time of Wendy's and the staff to review that to make sure that it's of quality.
I like that. We would have one course, but we would have different deliverers.
Which is the Virginia model. So one entity creates the course in various delivery formats, and then if Perry Moore wants to deliver that course, he would go there and get the materials. If he wants to do it live, he would get their materials for a live program.
Does he pay the TSCPA for the materials?
I think that you would have to consider that they'd have to recover their costs.
And your charge is $35, I think.
Yeah, $35 per
participant.
per participant.
It's like Wendy said a while ago, if they could do it internally, they would. I mean, but you could at the same time contract out your HR services, your HR internal, your payroll. You're subbing this out to them.
I think that makes the most sense to me, something like that, and that sets forth what these guidelines are, and they teach that course, and you're not evaluating all these different courses that are developed by others.
That's what I remember.
That's where we too, kind of where we were.
That's where we were headed with
last
it,
time.
and it was the basis for my question with you earlier was, and I didn't explain it quite as eloquently, but if they're willing to let somebody else use their material, obviously they've got costs to recover. But if they're going to hold the cost down for us online, and if we're willing to take it from them online or at a chapter meeting that.
I would propose that we work with the board and through Wendy determine what costs we have in the product and create a price model that would be clearly not intended to be a huge profit center of any type. But if we had like a per person head for some small groups, and if you had a group of 100 or 50 or more, there's some maximum cost, whether it's $500 or whatever, for the unlimited use of a course, for instance. There are a lot of different ways it could be priced. If price is the driving factor, I'm not of the opinion that this needs to be an economic model created to employ people from California to Maine in some economic
hopefully not
activity.
California.
That's bogus. But it's. I think the board's going down the right road to try to create some consistency and quality and accuracy in the information. And we're talking a 2-hour product that's either live or online. The online version is going to be consistent because it's going to be presented the same way every time.
I mean, let's be honest here, though. I mean, if we had 4 courses, they're 2-hour courses, which are really, 50-minute courses? Let's say 50-minute hours. Within a day, we could watch every single one of those. I mean, if it's biannually, I mean, you'd be doing 4 hours a year. I just don't think this is that onerous of a task. And again, I fully believe your product's going to be the gold standard. And I want you to charge whatever you think the market can bear. I mean, that's up to y'all. But I do like the idea of having some other people have the ability and flexibility to come in and say, look, I want to do this. I'm developing my content. And maybe they come up with something that's different than yours. I'm just saying it can make all the programs better, potentially.
As long as they've got the minimum content.
That's right.
I agree, and I think
They can
that's.
add whatever they want.
That's right.
As long as it's accurate.
That's right.
And that's essentially what Dr. Moore was saying.
To the provider of the basics that meet.
Must be in there.
I think
But now you're telling this guy he's got to go buy that from the society, whereas he's developed some content already. I just think that's kind of, I don't know. I don't necessarily agree with that.
the TSCPA has a vested interest in providing the quality product that we need to help people interpret our rules. And these are our rules when you get right, and we're going to regulate the people who violate these same rules. So I think it only makes sense to have the course itself developed by TSCPA. Now, other people can give the course, provide the instruction, provide the delivery mode, but I think the course needs to come from, in my opinion, it needs to be coming from one place that we control. And it's not about competition, it's about quality. It's about
exactly.
consistency.
And that's why you have the to me, that's why you would review them to make sure they meet the minimum standards. And if she wants to use that course as the basis for evaluation, she may not approve any other one. That's my point. Why tie ourselves to one?
Now, according to the rules,
She's saying we may not be able to do that.
some other providers could still do it. I mean, could Perry Moore still do it because he's at a university?
He could do it in the form of a credit course, or he can offer it as a non-credit short course so long as there's not a charge for that course. So I think for clarity, the only organizations where this board's discretion, if you will, has been removed to some element are professional development programs of the AICPA and any state accounting societies and their chapters, technical sessions at meetings of the AICPA, NASBA, and state accounting societies, universities, if they're doing credit programs or offering a free short course on campus that will equal actual time in class, and organized in-firm or in-house educational programs presented for employees and others without charge. Otherwise, anything that is not one of those organizations, it is entirely in your discretion to recognize or not recognize those programs for CPE credit.
Again, I look at this as our course, the board's course, and we're just simply using the resources that we don't have here at the board level, resources of the TSCPA to develop a course that we're comfortable with. And you know, I buy into the idea of having two different delivery methods, you know, live presentation or the video. But also, I think, you know, what Brad's saying, and I hope he would follow through with this, is he would let us review the pricing decision and have input into how our members are going to be charged for this thing, with the idea that the TSCPA is not enriching itself in any way by doing this. But it's our course, I think. I
think Brad should be able to enrich the organization if he so chooses. I mean, it's not up to me to set your pricing, and that's my point is I want you to charge whatever you think the practitioners will pay you to do the course. And my point is, if there's two or three, which I guarantee you, there's not going to be many left after this process gets passed. And even then, whatever they do submit may not pass muster anyways, and you just reject it.
I agree with you if this is open to multiple vendors that free market should prevail. But if this is going to be a course to meet the objectives that we've all discussed, being accurate and consistent, then price should be controlled to some extent. I mean, I can see the whoever the producer is, whether it's us or it's another a vendor that's creating the product, if there's only going to be one course, I don't think we should be allowed to charge whatever. We would have a monopoly at that point.
I would agree with that.
That would be problematic. But to identify costs and talk about recovering costs in some manner that's consistent with past practices, and we know where we are now, to be at that point or somewhere lower that's been reviewed and discussed and agreed upon by this board through your staff seems to be reasonable to me, to make some reasonable accommodations for cost recovery, but to create some consistent product. And there may be 2 or 3 or 4 vendors if you open it up to everyone, but the problem exists today that there are multiple vendors and there are some inconsistencies.
No doubt. And they're going away at the end of this year. I mean, we will not have a provider at the end of this year, period, because we've basically killed them all at the end of this year, right?
And the other alternative would be if we're worried about competition or worried about people wanting to be involved, the other alternative would be let these other folks submit courses. We evaluate all of them, but we're only going to pick one. and that controls the time that we have to spend as a board and the staff have to spend every 2 years, if that's what we were talking about a while ago.
Talking 4 hours a year.
Having to control.
I mean,
yeah, but
We'll have to reevaluate all of them every year, aren't we?
no, you're going to pick one vendor.
Forever, they're the one vendor. They've got to reapply every 2 years, the way I
No,
understand.
I'm not saying that. I'm saying this process that we're going to do right now, let everybody submit their course if we want to open it up, but we're only going to pick one course.
Forever.
Well, until we decide to redo it.
Right.
Well, let me, for example, Dr. Moore may not want to present or prepare an online course. He may decide that he wants to do only live in-class training, and so I don't think it's fair to burden him or someone else with that burden. I think really it's the market who makes the choice, the people who are consuming the training. And I'm, Trey, with you, I don't know why we would arbitrarily limit up front who can try to put forward a course that would be suitable for our requirements.
My question there would be, how many times can they resubmit? I mean, how many times does Wendy and her staff have to evaluate what they're sending in? I mean, or is their first time they send it in, is that their only opportunity to get a pass or fail?
In my mind.
Or, because, I mean, you might have
Understand, my first preference would be, say, we're going to contract out with
That's my
TSCPA,
preference.
and we're going to go with one vendor, and that's our decision, because these are our rules, and this is
Even-
our course.
But even in that case, I mean, we've been through 2 rounds with the Tennessee Society trying to get the course tweaked and to our liking, and so it took more than once even for them. So I don't know that I would arbitrarily limit the number of submissions. We all want the best course availability for our people.
So that'd be more than
These
4
courses
hours.
were submitted like 10 years ago.
Right.
And nobody's looked at them since then.
We started
That's
with
the problem.
Well, we started with the request to just review the quality, and then we determined there was a problem. And my thought is, if we're not going to have one vendor, just have everybody submit it, and if you reject, you reject. That's it. There's no resubmit. It's just give us your best, and then we decide that's 2 years, and then in 2 years, everybody goes away and we do it again. So I mean, you're talking potentially 4 or 5 hours. I don't know, 6 hours. I mean, because I mean, we only had 3 people provided responses to us on this. So obviously,
I'll agree
only
that
3 cared.
If we all
or
agree
4.
that TSCPA would be the gold standard, why would we as a board want anybody who is a CPA to take something less than the gold standard?
We're not saying we would
We're
approve
making-
anything that was less.
We're making the assumption that they are. I mean, I'm not saying there could still be someone that provides good, quality,
The one that
accurate
provides, I
information.
presume he provides a quality course. I mean,
I just have
Multiple Big Four firms have utilized him from a firm employer perspective. He presents at the Lipscomb Annual CPE Conference. It is a good course. I mean, I can testify to that personally, but he may not be the only provider or that's
right.
capable of providing a good course.
I think my concern is when I asked legal if there was a concern about a monopoly, and there was not. If she had said no, I have no problem. But now, if we've got to go back to a
Let me
Better-
clarify. Now I've had a little time to look at it. I believe that you do have broad discretion to select who your provider is, and I'm contacting with Chief Counsel just to make sure that I'm not off base. I do believe you have broad discretion to choose a private provider on what you are going to recognize. I don't think that you risk any sort of individual liability if North Carolina is kind of floating around. I don't believe you open yourself up to that. I think a scenario where you would open yourself up to that is if, instead of just denying CPEs, state-specific ethics CPEs from people who maybe just go out and do it anyway. So say we have licensees who are like, well, I took a course through this organization, but they weren't receiving their materials from TSCPA or from someone that you choose to accept. That all we do is deny those CPEs and tell them they have to get them from a qualified person. Where liability would likely come in is if you said, if then we as the board try to contact the CPE, the provider of the unauthorized CPE, and tell them they cannot continue to do so. I think at that point, those are people we don't necessarily regulate directly. The authority of the board now is only to say which CPEs you will deem qualified and which you will accept, but not to control what these essentially are third parties, what they're providing. So I think so long as you're only talking about what it is you want to accept, when you're talking about your licensees meeting their requirements, you are more than fine to determine what private organization you get those through.
So y'all, just to clarify, I'm slower than the average bear.
I talk too fast, so that's
So,
all right.
if we make a motion here and pass it that says we are granting the TSCPA to be the sole provider of CPE, both online, live, however that, any methodology, there's no issue from the legal counsel side.
Course content.
I would restrict it to ethics, and I would also
Yeah, just for the state-specific
I would
ethics.
strongly encourage this board to review a contract between yourself and TSCPA before you give them that sole authority. I think that it's best to enter into that relationship in a contractual nature. That way, the quality, the service, the timing, how it's offered, costs if you do want to do offsets, all of that can be determined contractually, so we don't end up in a position where the only sole provider, obviously a very esteemed organization, but that this board is hampered if something were to happen with TSCPA, where we'd have to come back together, wait for a meeting, and then re-vote. So I think because you're acting like it's a vendor relationship essentially, I think a contract, and that's something Wendy and Ben had talked about before this, a contract would be essential. So I don't, if you want, I would say maybe a motion to enter it or to receive drafts of that contract for review might be appropriate, if that's
We already have a
happening.
motion on the floor.
Right.
Let's vote on that motion.
Why don't we dispatch that?
And just to be clear, we're talking about course content coming from a sole source. Is that what everybody
Which
is?
somebody would have to buy to then teach.
Right.
That's not the motion. The motion
The motion right now is to provide
Discussion has
multiple.
gone beyond just the motion.
Yeah.
So to clarify it, that's where I think I hear everybody heading. We still have a motion and a second on the floor.
Vote on that motion.
And vote on that motion.
For multiple providers.
For multiple providers. That motion.
Whatever, biannual review.
Okay, let's vote on that motion then. Let's roll call it just to prevent confusion.
Pamela Church.
Aye.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
Don Royston.
Nay.
Janet Booker Davis.
Aye.
Judy Weatherby.
Aye.
Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Aye.
Ayes have it. Now, does someone want to make a motion based on where I think I heard the drift coming before?
I would make the motion that we enter into a contract with TSCPA to provide the board with a course, an ethics course that would be able to be purchased by individuals or by other groups who wanted to deliver the course, but that the course content had to be coming from them under this contractual relationship that we would enter into.
It be state-specific ethics.
State-specific, yes. Now, I may not have said that.
Motion.
I second that motion.
Okay, we have a motion and a second. Is there anything else we can discuss? Hearing none, let's have a roll call vote on that one.
Pamela Church.
Aye.
Trey Watkins.
Aye.
Stephen Eldridge.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Janet Booker Davis.
Aye.
Judy Weatherby. Aye. Gay Moon.
Aye.
Larry Elmore.
Aye.
Kevin Monroe.
Nay.
We were consistent, Kevin.
It's been a good discussion. I think it's been a good discussion.
I think that
Yeah,
takes
we just
care
got
of
put on the
the
database.
discussions regarding that.
Scarlet letter.
May I ask for a little bit of detail from a contract perspective? There were several things I talked about in Virginia that I would like to understand if you are for these types of things, meaning are you interested in this board approving an outline that they would need to go by? Are you okay with them just creating something based on, our interaction, staff's interaction with them?
My understanding, and I want everybody's input, but it's my understanding you have an outline already that they started with to provide theirs.
Correct.
We each have had an opportunity to look at that course itself, and make some tweaks to it. I would assume that we would, under this contract, that we would approve the final course that's referred to in this having full content. And then it would, it'd be subject for us to do an annual review to be sure it's covering the content. I mean, they're in the best position. They're here every meeting. They're here through the committee meetings. And I don't know how many states have the luxury we have of having a good relationship with us. They do our peer review, run the peer review program. So, I think that's where I see us heading without it making it too bulky of a contract.
So an annual review, the course would be approved by this board. Do you want to approve an updated outline? It's been a while. Now, keep in mind, they've already created something, under the current premise, or the current...
We've seen it. We've seen that product.
Right, you've seen that product. So do we want to maintain the idea of an outline that would give them guidance on creating the course?
I think from a board standpoint, personally, that we would want to maintain an outline at some point and add to that so that we work continually because, with the fluid nature of their product, I think they would be able to update in mid-year if we made a change to something that's going on. They're going to add that to the content.
Right.
That's the advantage we have of the single provider of content.
Not sure there's any need for an outline, quite frankly. I mean,
The running product would be the thing I see.
their deal is going to be it. I mean, you're going to be providing, they've already got the materials.
So when you approve it, let's say you approve it at every January meeting to be, to start delivering, February 1 or March 1 or whatever. Do we need something to know what you're approving, meaning to base your approval on? And that's where I see the outline coming in. Okay, well, did the course cover all of these items in the outline? Or if there's nothing, are you okay just viewing it and saying, yeah, we like it?
I don't see a downside to having an outline.
Okay.
Bottom line is we're all going to have to take this course.
Yeah, I know. I guess I'm thinking Virginia has this very specifically laid out, and I'm wondering if we want to be as specific. I think I had alluded to the fact they have created a separate committee that creates the outline that's approved by the board, and then the society takes that outline and creates the product.
I also hold a Virginia certificate, so I've taken that course.
That course. So are you interested in a separate committee that creates this outline, or are you comfortable with the licensing committee, reviewing an outline annually?
I would.
I think I would
Make it
defer
as
to
simple,
staff and have
yeah.
staff present it to us to say, we have reviewed it for necessary items or what we think is, you've evaluated these other courses, so I assume you had some basis for evaluation.
On that old, outline, basically.
Right.
I'd try to keep it as simple as possible. I'm not for having another subcommittee of the board, but it seems to me the staff could help update the outline based on what they know about what's going on, and it could be presented and discussed in the licensing committee, and then approval recommended for the whole board.
Okay.
Like the annual approval, like you're saying, and thinking of the rolling nature of boards, not only from board members but staff, then you've got a documented.
That's what I would like, because if all of a sudden we get to a meeting 2 years from now and go, well we're approving this, but what are we approving? And so I just want to make sure that we're getting enough detail that gives future boards guidance on what it is that their responsibility is, and the TSCPA to understand, well, when I go create a course, what do y'all want? Is this an informal, what's going on with complaints recently type thing, or should it be more formalized with the outline? So
I think if you put the outline out and let the licensing committee approach it, say the October meeting, and then it rolls forward for the approval of the product in January, that gives some time to tweak additions we think, having feedback from our members, because you're getting course evaluations on everything.
we don't get courses.
No, but they get them, and
do.
they can provide them as part of our contract.
Right.
Open discussion. Anything further on that?
Not that I'm aware of.
Okay. Mr. Annual Report on oversight under old business. Any more old business, by the way? I'd like to have it. He disappeared on us.
I just wanted to follow up, but on this mobility issue, tell me again where we stand with that. What are we doing going forward with these states that don't provide mobility like we provided?
This board voted at the last meeting to seek quid pro quo legislation.
Okay.
So
that's what you said earlier.
That will likely not happen this session.
This year. Okay.
Under old business is, I was going to get Gabe to update us on his quadruplets, but
He said they're sleeping now.
they're sleeping now. I figured he got a little testy today. I wasn't sure whether that's because of lack of sleep or not.
Put it on the database.
Yeah, he's got a database at the house.
You just got marked.
Okay, new business. We have a new face up here.
You have two documents on your iPads related to peer review. The first document is titled Peer Review 2016 Administrative Oversight Report from AICPA. And just to give you a little bit of background as to what this is, every other year we are required to have a representative from the AICPA Oversight Task Force come in and review the administration of the peer review program. In the off years, we have a member of our committee who does an oversight not quite as robust as what the AICPA comes in and does. The purpose of the oversight process is for them to review our administrative procedures and make sure that we are complying with the procedures set forth by the peer review board, to review our to make sure that our reviews are conducted in accordance with standards, to review the process of our RABs and our technical reviewers to make sure that the results of reviews are being considered and evaluated appropriately, and then lastly, to make sure that as an administrating entity, we are communicating with firms and reviewers on a timely and accurate basis. So on November 10th and 11th, we had Paul and Sarah, who's a member of the AICPA Oversight Task Force, and Brad Coffey, who is an AICPA technical manager, come in and spend 2 days with us. They reviewed our policies and procedures related to the peer review program. They met with both myself and Katie Cheek, who are involved in the day-to-day administration of the program. They met with our technical reviewer, Art Sparks. They pulled past reviews. They pulled reviews in progress. They reviewed our own oversights that we perform, and they also sat in on a review acceptance body meeting to observe their consideration and discussion around review results, and then sat in on a full committee meeting as well. So the letter that you have is the results of that observation, and we were very pleased that there were no findings. They felt that we, in all material aspects, are complying with the program procedures and standards that are set forth. And, there's been a lot of transition in the last year and a half with Wendy leaving. We have a new technical reviewer, new staff involved in the program, so we couldn't be more pleased that we got a clean report and that we are administering the program to the same level of quality that Wendy and her staff did for so many years. We also feel like this further supports what we had been saying to the AICPA when they issued their proposal last year, that Tennessee, the TSCPA, is well equipped and well qualified to continue to administer the program. So we're glad that this supports that. Any questions before I move to the next document? The second document that you have is titled Peer Review 2016 TSCPA Annual Oversight Report. This is a document that we are required to submit to the AICPA annually. It provides an overview of the program. It also provides year-over-year statistics related to the firms that TSCPA administers. So these are firms who are enrolled in the AIC, that are in Tennessee, that are enrolled in the AICPA program, as well as those firms who are not AICPA members, so they're enrolled in the TSCPA program. Just a couple of quick things I want to point out. If you look at Exhibit B in that document, this shows you the results of reviews for the last 3 years. And I'm happy to report that for system reviews, the number of pass reports from 2014 to 2015 increased, so that's good news. And then engagement reviews, the number of pass reports for firms enrolled in the AICPA program stayed relatively the same. It went from 92% to 91%. And then for engagement review, pass reports for those firms enrolled in the TSCPA program, it went from 81 to 88. So again, an increase there. You'll see overall in 2014 we administered 275 reviews, and in 2015 we administered 234 reviews. The next schedule is Exhibit E. I wanted to point out a few things. This just gives you all an idea of the types of corrective actions that our committee is requiring firms to complete when they have a pass with deficiencies or a fail report. Oftentimes, it's a requirement to provide proof of CPE or to agree to take a certain number of hours of CPE in a specific content area. Pre-issuance reviews are another corrective action that is often required, or a requirement to submit work papers if there's been an issue with a particular type of an engagement, that for the next engagement of that type that the firm performs, that they would provide those work papers to the team captain for review to ensure that the issues noted in the peer review have been resolved. So again, just an idea of the types of corrective actions that we're requiring. And then lastly, on the very last page, you'll see some statistics related to oversight. We are required by standards to oversight a certain number of system and engagement reviews, and we complied with all of those in 2016. And then we are also annually required to review at least 1/3 of our reviewers' resumes to make sure that they are still qualified to act as a reviewer. We have 76 active reviewers, and in 2016 we reviewed 31 resumes. We reviewed about 40% of our reviewers and had no issues there. Any questions on that information?
Y'all review the, I guess on the SRMs when they get submitted, do y'all, I guess, on every single peer review, do you not ensure that, I would say that's 100% review right there, right?
Yes, it is. We look at that when we get that document and check it in, and then it's looked at also by the technical reviewer. Anything else? Thank you.
We thank you. Is there anything further to come before the board?
No, sir, that concludes the agenda.
Chairman, I don't know if it's of a concern or not, but legal is huddling out in the hall about this last thing we voted on, I think, so I don't know if...
Yeah. Let's let Liz check with them and see if
Okay.
they would like us to hold off on adjourning or not.
I'll say it didn't concern you, but...
No. I just don't want to leave and then find out that they think we did something we shouldn't have.
Do what now?
Legal is absent from our meeting because they're talking about, I think, this last vote we did on the...
They're just deciding who goes on that database. Which one of us?
Sorry, I have a legal powwow. I apologize. Tony's going to come in.
That doesn't violate a sunshine law?
I don't have the privilege of being a member of this board, but I wish I did.
We're so sunny.
Tony came down because I was just informing him he was looking at me, over text kind of what was going on. And I wanted to, especially as a new member to the accountancy board and new to the law, I definitely don't want to mislead the board. And I wanted to make sure council backed up anything from a legal perspective of moving forward with the TSCPA as a sole provider of materials. So I don't know if you had any specific questions to help guide Tony to look at, to answer for you, or...
Tony, see any problems with doing it? I mean, it's really all I want to know.
Well, not seeing the discussion, I think well, in looking at the history of it, I mean, I would have had some concern in the past probably about sending a letter out telling certain organizations or people, like, we're not doing these anymore, because the question is whether or not they had a property right at that point in time that was granted by the state that would have given them that, and whether or not we had to do a different procedure and give them like more of an actual protest, you know. But I don't. But I hadn't really had a chance to look at that in the future, you know, really in depth. But I think the way that your rule is crafted, and from my understanding of what wants to be done, I think the board could easily approve someone like TSCPA materials to be used. But it looks like your rule right now allows for the door to be open that other people could be approved, and I would just suggest not to say it's this one and only this one and nobody else could be, because your rule really allows for you all to approve other than just one. And so since the rule says right now you could approve more than just one, then somebody could come in and say, please approve me, and you all may say, well, no, we voted last meeting, we're only doing one, and that wouldn't be in compliance with your rule. So if you all were going to approve one, I would just approve it and not and just kind of leave the door open that if anybody else wanted to come in and pitch their spiel to you all, to allow that to kind of happen. Not that you would have to approve them or not.
So are you saying we need to change, or I got a little
Basically, the
lost?
first motion is what we should have passed. That's what he's saying, right?
And then I would like to also have legal have the ability to go back and look and see if we're going to run into any errors, like a need of a contract. That's always a question, is a need of a contract, and quite honestly, that's not my forte. We have one attorney upstairs who's kind of in charge of all of the contracts for the department to see if one would be necessary. I'm not so positive that one would be, but I would allow them to make that call.
Our motion was to provide them as the content provider with availability for other people to use that content, so that we're controlling, since it's state-specific ethics, and then to empower Wendy to work on a contract. And I guess that anything we've done to this point can be changed, because at our next meeting, when those answers are forthcoming.
I don't think. Yeah, I didn't hear anything in that motion that would exclude anybody else from coming before you all and saying, hey, could we be looked at? So I'd be.
I think that we've specifically excluded. That was the intent of that motion.
You said they had to use the content.
Right, but I mean,
You got to use the same content.
right.
Right. So your rule allows you to approve multiple persons, and you've approved just one, so long as the approval isn't this one and anybody in the future who comes before us, we're always going to say no. That would be my fear would be.
What we approved was that other people can present the course material that they develop. Does that, I mean, so...
Yes, I like that. Yes, I think
that's what we
does
approved.
go into the compliance. That really kind of goes with the spirit of the rule.
They can purchase it just like they're going to develop it. It's a whole lot easier to work with a product and then add to, as long as that minimum content is involved, was what the discussion was.
What we voted on did not say we wouldn't ever consider someone else. It said, today we're voting to approve them as the provider. It didn't say we would never consider anyone else.
Yes, I'd be comfortable with that. Yeah, and I'd be comfortable with that, and I think that has minimum liabilities to the board.
Was the contract going to have a specific amount of time? Wasn't it going to be annual?
Well,
it was.
I think,
Fine.
yeah,
I think you're right.
an annual approval of the content.
No one else would be provided for 1 year. Is that in violation of our rules?
Well, I mean, so long as if somebody came before you all did not disapprove them, saying, well, we had a motion last year and we wouldn't allow anybody else to do that, because your rule now says that anybody could come forward and at least have the opportunity to present something.
As long as they present that content. Is that, I mean, that's what I just want the content.
Anybody
Yeah.
can present it, but we
just-
want to control the content that's
Right.
being presented.
I just want to make sure that we're...
Okay, so this might help, I don't know.
I'm confused
Let me know.
now.
No, so I explained to you at the beginning that Virginia has, they have individuals who would like to present the course have to apply with the board. It's a simple one-page application in which they attest that they have an active license within that state and that they agreed to get the content from the society. And then those folks are approved and listed on the state board's website as approved providers of that course. So therefore, Dr. Moore, for example, could apply to be a presenter. but he would have to agree to keep his license active and to get the content from the society. So that wasn't part of the motion, but it might help.
No, I think it was. My motion said that we would allow other people to present this course.
Okay.
Do you see a problem? I guess here's, in that example is really the prime example. We have an individual who currently teaches ethics. He has his own course content, which we have previously approved. At the end of 17, we're terminating all CPE ethics courses, and we're going through a new renewal process to do it. What we just voted on was to make or get the society to be the sole provider of the material that's going to be taught. So this individual now will have to go to the society, get their materials, presumably pay some minimum cost to present the materials. That's the issue.
Right. And I think
And you think we're okay there?
I think you're okay with doing that. Now, if that individual comes back and says, hey, you said I can't use mine, I'd like to show it to you and you all may reconsider.
I think this motion prohibits that from occurring.
No, it didn't say we wouldn't ever consider anybody else. It says
Not
today.
ever.
That's for 1 year, doesn't
No,
it?
it said today we're voting to do this. Now, it doesn't say tomorrow we wouldn't reconsider that.
Well, it says we can't have both. I mean, we're only going to have one content provider, is the way I
Right.
interpreted that approved motion.
But it didn't say we wouldn't ever consider changing that. You're saying our rule says other people can provide it. It doesn't say we have to have multiple providers.
Exactly. Yes, that's what I'm saying. Is that your rule? Yes, that's exactly.
So it just says don't exclude anybody totally.
What if somebody shows up 6 months and says, I've got this content I want to submit? What would you say?
Well, they could submit it, and if we have a contract active for a year, remaining time on that contract 6 months, then if we felt that this new person presented a better product, then we could opt to enter a contract with this provider, a new provider. Would that?
You could. You could say, yes, we can, or
Yeah.
6 months from now, they can provide it to you, and you all say,
We could,
looks good, but no thank you.
Yeah.
You know.
we could make it an annual or biannual period where we decide on which content we approve. And then they can submit, there's clear deadlines for submitting their content or something like that. I think the way we're headed is the right way, personally.
Keep in mind from someone like, I hate to keep using Dr. Moore, but he is the one that commented, and he does do a lot of courses, but it doesn't mean that he can no longer provide that course. It could still count as technical content to meet another CPE requirement. It might not meet this.
Nobody's going to go through, that's unrealistic, because nobody's
Yeah.
going to
Right, and I agree with you, but he could alter it, call it a general ethics course. There might not be the demand for it.
I think he's hired because of the demand for
Right.
Tennessee state-specific ethics
It also cuts
courses.
his profit in half.
Because you're going to hear from him. He's
Probably.
going to complain.
Yeah.
Which is why I was getting a little worried about being the sole provider thing. That's why.
I doubt that
Well,
he
I
would
think
have
we-
any desire to present an online
We've now
course.
penalized this guy. That's what this board just did, is penalize that guy. And so I talked it to death. I think we've pretty much come to
But
the
I guess
conclusion.
the
think
question,
legal's
I'm
fine
not
with
getting
it.
a clear perception of whether you're saying what we have done, which is, we really have given TSCPA exclusive rights for a year. Is that in violation of our?
I would just make the motion so that it doesn't just give it the exclusive right for the year, that you just approve them for a year. It doesn't give exclusive rights, it just
Well, I think
approves them for a year.
for the content, I think our whole issue is to make sure the content is consistent. So, all we're giving them, we're just saying everyone has to use their content. They've developed it, they've worked closely with our staff, it's what we want people to learn, whether they sit in Dr. Moore's live class or they take it online. And anybody who wants to present it live or whatever, they can get it from the TSCPA. Is that, I guess I'm just really confused right
Well,
now.
I mean, I don't know, maybe in perspective, the way I looked at it is that you previously had multiple, we're calling it content, is that what we're calling it?
Well, there's two different
Course
levels of
providers.
authority.
Okay.
You can
I don't
call
want
it-
to, get lost in just,
Each provider-
words that I'm
each
using
provider
that's
did
confusing
his
you
or
all,
her
but
own
if you had multiple people, if you had multiple, however,
Yes.
and, last year, 3 of them, and your rule, that's what your rule says, is that you can approve multiple ones that come before you, and now you've whittled it down to 1, so long as you keep sight that you can't whittle it down to 1 in a motion and say this is ever it, because your rule doesn't allow you to do that. Your rule
Does it
says
allow
that-
us to do it for a year?
And disapprove content.
That's it.
Which
That's
is
right.
what we were trying to get at earlier.
But does it allow
I
us to
think
do
we
it
went
for
the
a
other
year,
direction.
which is what we just did?
Well, I mean, your rule doesn't say for how long. It doesn't say for how long. It's just kind of,
And the problem with having the multiple vendor, the whole reason it came up was they weren't covering,
right.
and they were inaccurate. They weren't covering the material properly, and they were inaccurate.
I think, Tony, if I may, I think one of the confusions that's arising is the difference between board-approved content, or let's take the word content out because it's actually not in the rule, board-approved state-specific ethics versus qualifying a program. I think because the rule that we're looking at as far as your authority to, that Tony and I looked at, as far as the board's authority to qualify a program, is related to that, is for the program as a totality. Whether this can be a CPE provider or that is approved by the board. But then it seems to be that the board is distinguishing that from saying board-approved specific ethics courses, which would go to the content that we discussed. And
This
so-
isn't worth the amount of time that we're spending. I mean, this is crazy. We've just now talked ourselves into a circle.
I'm confused as to
It
why,
is- I agree with
if our
that.
rule says we can allow multiple people, that doesn't mean we have to.
That was the
I'm not an
intent of
attorney,
the
but-
original motion.
and that
It
you
was-
have to. What I'm saying
you're
is that
saying we-
your rule allows the opportunity for somebody to come here and say, please use ours, and if you deny them, you shouldn't be denying them saying, because we made a motion previously saying we weren't going to use anybody. I would ask that you just deny them, saying that we just don't want we just don't want you to provide this.
Or we could,
So what's
can we
the-
not
so
say?
we don't, I don't think we have an issue then.
We're denying you because we have a contract with TSCPA.
Well, I think we
for
have,
next
because
year.
we've entered into an exclusive arrangement with the society.
We didn't say we wouldn't consider anyone else if they came along. We
Well,
just
they
said-
are the sole source
We
content.
rejected the preceding motion.
Contract's going to say that, I'm sure.
And we use the term sole source. I mean, I don't know. My whole point was,
That didn't really
is
help.
why not just say, I mean, this gets me back to the original argument of, let her approve the content of the materials. Why give any exclusivity? And then just let her determine whether or not the course content meets the standard or not. And in that way, you've got no problem.
Somebody saying, well, why didn't you approve my course?
Because it didn't meet the standards.
If we don't ask for anybody else to submit one, we don't have that problem.
Yeah, and
No,
she
but
has the
you have
ability to approve and
People that have
disapprove.
submitted them in the past and might be willing to continue to submit them. And
What would be wrong with saying if somebody submits one, saying, we've already engaged TSCPA for this contractual period, you're welcome to submit yours next year?
I felt like Tony was saying that's probably not a good argument. Did I hear you say that? Because we already entered into an agreement with someone else?
Contract, our rule says you can engage multiple, not that you will.
It doesn't.
What does it say? Can you read this through?
Says must, shall.
It says
will.
all license holders shall complete a board-approved 2-hour state-specific ethics course designed to familiarize the licensee with accountancy law and rules as well as professional ethics. That's all.
Then there's another part that
Well,
says.
it's section .04, I think, that Tony and I have been looking at, which has to do with which programs can provide those. Which programs can provide those board-approved ethics hours. And this section has programs requiring attendance may be considered for credit if, and then a list of things that that you would maybe consider a program to allow qualified board credit to be offered. And so that may language is, I think, where Tony's pointing to say, we don't want to across the board just tell people we're not going to consider your program at all. But rather, it's okay that you decided that the board-approved program is TSCPA, but you can't tell them that they can't appear at all and try. I think you can still have the authority to deny them, but you have to let them at least send you the materials. You can still deny them, you can still abide by the contract that you've chosen to. There's still no liability on that front of that, but you can't tell them you can't try. But you can absolutely
If you're
deny.
abiding by this contract, you do have to tell the others they can't try.
You can deny it on the basis of the contract, but you can't tell them they can't submit it to you.
I don't know why we're painting ourselves in this box.
It's kind of a legal distinction. I don't know if it has a practical effect.
This is crazy. Just approve or disapprove the ones that don't meet the qualifications and just be done with it. And if that's only the AICPA or the
seems to
Tennessee
me
Society that's left, just be
We
done.
made a decision, now the only question is it legal?
I
And I don't
believe-
think that's for us to debate, I think that's for y'all to tell us.
That's what I was going to ask. Is legal counsel okay with what we've done, or are you telling us we must do something different?
It's our understanding, I believe, that the decision to use TSCPA and to enter into the contract you're talking about is
An
okay.
exclusive contract.
Yeah,
And
then it's,
I would ask that we cut debate off on this whole issue. We've talked about it way too much.
I'm
It's
in
still
agreement.
an evolving process. If it turns out there are problems in drafting a contract
Right.
and legal counsel studies it further and sees there's a problem, we can change directions
Right.
later. But we're just talking in circles here. If we're okay with what we've done, we've had a motion, a second, a vote, I suggest we go home.
Thank you. Is that a vote, a
Yes.
motion for adjournment?
Yes.
Thank you. We're adjourned. Thank you. Thank
just
you.
trying to make sure.
Lauren. See you, buddy. Yeah. I appreciate you coming that way. I don't want to cut down the chair because I think it's important. If the horse was dead.
There's nothing wrong with that.
We're going to bury the horse now.